Ladies and gentlemen, welcome to the second day of Hong Kong Legal Week 2021 International Criminal Law Conference. I'm so honored to be your MC today. I'm Yo Leung. Hello everyone, good morning. 早晨，早晨，早上好。The conference will be divided into the morning and afternoon sections in English, with separate channels for simultaneous interpretation in Cantonese and Putonghua for live and online participants. Now, may I first invite the Honorable Ms. Teresa Chang, Secretary for Justice of the Hong Kong Special Administrative Region Government, to deliver her welcome remarks. Ms. Chang, please.
Distinguished guests, ladies and gentlemen, may I first extend our warmest welcome to you all, both here in the audience and online, for participating in the 2021 International Criminal Law Conference. Hong Kong is a society and an economy premised on the rule of law. In this regard, the Department of Justice enjoys an independence which is constitutionally guaranteed. Article 63 of the Basic Law stipulates that the department shall control criminal prosecutions free from any interference. Our prosecutors act independently, without fear or favor, and free from political interference or undue influence. Hong Kong's judicial independence is premised on the solid infrastructure that has been laid down in the Basic Law, including the security of tenure, the immunity of judges, and, importantly, the express provision in Article 85 of the Basic Law that guarantees judicial independence free from any interference. All judges are required to administer justice without fear or favor and to adjudicate only in accordance with the law and evidence. In today's ever-changing society, technological advances are accelerating in many areas. Therefore, in addition to keeping the core values intact, we must remain vigilant of the need for changes and reform to ensure that our criminal justice system remains fair and effective. To this end, this conference provides a platform for exchanges to examine experience from other jurisdictions and to review our own practices with a view to enhancing the development of the criminal justice system. 4 topics have been chosen for today's discussion. Both the Basic Law and the Hong Kong Bill of Rights guarantee the freedom of expression and peaceful assembly as fundamental rights. These rights are precious and are of cardinal importance for the stability and progress of society. Yet, none of these rights is absolute, and they may be subject to lawful restrictions. For example, as pointed out by the Court of Final Appeal, under Article 17 of the Bill of Rights, the freedom of assembly is not absolute, but is subject to lawful restrictions, including the interests of public safety, public order, and the protection of the rights and freedoms of others. The freedom of speech and expression is similarly subject to lawful restrictions, as apparent from the wording of Article 16, subclause 3 of the Bill of Rights. When assessing the bearing of human rights against other interests, the courts in Hong Kong recognize that a balance has to be struck. In a case involving a challenge to the constitutionality of a permission scheme that required applications to be made for use of government premises for holding public order events, the Court of Appeal acknowledged that the government has to strike a balance between the need for public order and public safety and the orderly operation of the officers, and the need to facilitate public expression of opinion. Similarly, the European Court of Human Rights has acknowledged that the right to freedom of assembly is subject to exceptions, and interferences with such right could be justified for the prevention of disorder, or crime, and for the protection of the rights and freedoms of others where demonstrators engage in acts of violence. These considerations highlight the importance of putting in place a system that strikes the right balance between the protection of human rights and the need to protect the community from criminal activities. Sentencing is an essential part of the administration of criminal justice, which has always been exercised by the court's independent judicial power. Some suggested that this should be revisited. But should we not first identify the problem that has to be addressed? Is there not a well-structured system already in place to ensure proper principles are actually applied in accordance with the laws, as opposed to merely paying lip service? We will hear the views from experts on this, taking into account, I believe, the experience overseas. Another aspect of sentencing relates to the role of prosecutor. In a 1989 case, the Attorney General versus Jim Chong-Shing, the court endorsed the principle set out in the Conduct of Counsel for the Bar of Hong Kong that a prosecutor should not attempt by advocacy to influence the court in regard to sentence. The court further held that a prosecutor should not submit to the sentencing court decisions which merely uphold, reduce, or increase a particular sentence, or say anything that could be taken as advocating severity. On the other hand, there has been suggestion that a prosecutor should be allowed to assist the sentencing court more actively. It was observed that the more the prosecution can play a part in the sentencing process, the less likely it is that the need will arise for the prosecution to appeal against a manifestly inadequate sentence. This may have the effect of saving judicial resources. We look forward to the stakeholders' views on these matters, and we are also keeping an open mind on suggestions as to how we may better assist the court. A comprehensive legal and structured framework to combat corruption is an important aspect of the rule of law. We will hear from the Commissioner of ICAC on their experience in Hong Kong and the representative from the Supreme People's Procuratorate on the practice in the mainland. In Hong Kong, the common law offense of misconduct in public office is a powerful tool in combating public sector corruption since it covers various forms of abuse of power by officials. I take pride to say that Hong Kong's commitment to combating corruption is recognized internationally. In the Corruption Perceptions Index 2020, published by Transparency International, among 180 jurisdictions or territories covered in the report, Hong Kong was ranked the 11th least corrupt place. Nonetheless, we must not be complacent and must continue to evaluate the system and improve. With the rapid development of the internet and social media, crowdfunding activities have become increasingly prevalent over the past few years. There is currently no specific legislation to regulate crowdfunding in Hong Kong. However, depending on the specific structure or features of the relevant arrangement, certain types of crowdfunding activities may constitute criminal offenses. For example, a charge of fraud might be applicable to a crowdfunding scam where the culprits induce potential investors to contribute or invest in their companies by making false representations as to the prospect of their product or business plans. There have been suggestions that crowdfunding should be specifically regulated in Hong Kong so as to set up a framework to facilitate the proper and legitimate development of crowdfunding. Different jurisdictions have their own ways of responding to crowdfunding, and we will hear from experts on the practice in the UK. The overseas experience in this area of law will certainly provide us with useful reference. I wish to take this opportunity to extend my sincere gratitude to the moderators and speakers, all of whom have kindly taken time out of their busy schedules to share with us their insights. No doubt we will benefit immensely from their sharing. Last but not the least, my special thanks goes to the organizing team of the Prosecution Division, especially Mr. William Tam, SC, Deputy Director of Public Prosecutions, for the time, efforts, and dedication they put in this conference, which make it possible. I look forward to the insightful and stimulating discussions to come. Thank you very much.
Thank you very much, Ms. Zhang. Thank you so much. Thank you, and please be seated. There will be 2 panel sections in this morning. For the first panel discussion on human rights consideration in the criminal law context, we are very delighted to have Ms. Vincy Lam, SC, as our moderator. Ms. Vincy Lam is the Deputy Director of Public Prosecutions, Department of Justice of the Hong Kong Special Administrative Region, Hong Kong SAR. She specialized in criminal appellate work and was formerly head of the Advocacy and Appeals Subdivision, overseeing trial specialists and all criminal appeals and reviews. Ms. Lam, the floor is yours. Thank you.
Thank you. Secretary for Justice, distinguished guests, ladies and gentlemen here at the Convention Center and online, good morning. I extend a very warm welcome to each of you to the first session of today's conference. We start off with an important topic, which is human rights considerations in the context of criminal law. Now, as the name of it connotes, we will discuss in this session the interplay between human rights and in the criminal law context. Now, we have today very lucky to have 3 distinguished guests, speakers, to discuss the topic with us. Without further ado, can I first introduce our first speaker? Now, our first speaker is Mr. Justice Henry Litton. Justice Litton was a permanent judge of the Hong Kong Court of Final Appeal from 1997 to year 2000, and then a non-permanent judge of the same court for 14 years until 2014 when he retired. He was born in Hong Kong and graduated from Merton College, University of Oxford. Justice Litton was called to the English bar in 1959 and to the Hong Kong bar the next year. He joined the Hong Kong judiciary as a Justice of Appeal in 1992 and was appointed Vice President of the Court of Appeal 3 years later. He was awarded the Grand Bohemian Medal in year 2000 and appointed Honorary Professor of the Faculty of Law of the University of Hong Kong in 2014. Justice Litton joins us by way of a recorded video.
When considering human rights in the context of the criminal law, the key words are a fair trial. Now, this concept runs through the whole of the criminal law as practiced in Hong Kong, and indeed in all other common law jurisdictions, though there would be different shades of interpretation as to what precisely such concept entails. The national security law is a Chinese mainland law. The interpretation of that law, however, is done through the prism of the Hong Kong common law courts, which have sole enforcement responsibility except in 3 narrow areas. In that law, all the requirements of a fair criminal trial under the common law are expressly guaranteed. This gives real substance to the policy of one country, 2 systems. There's nothing exceptional in this regard. It is simply reinforcement of Article 87.2 of the Basic Right and Article 10 of the Bill of Rights. Now, when lawyers speak of a fair criminal trial, the first thought that springs to mind is the quote-unquote golden thread seen running through the English criminal process as articulated in the leading case of Wilmington against DPP, Director of Public Prosecutions, an English House of Lords case, whereby the burden of proof lies generally with the prosecution, and to convict, there must be proof beyond a reasonable doubt. That case was decided in 1935. Now, wind the clock back to 1897, and the scene was very different. Although the golden thread running through English criminal law was already in place. But whether it produced a fair trial is a different story. At that time, an accused was deemed incompetent to testify on oath in his own defense. The oath was afforded great weight. Now, an unsworn statement was one thing, but when a person stepped into the witness box, placing his hand on the Holy Bible and swore to tell the truth, he had put his own immortal soul on the line. The courts were in effect saying this to the accused. Now look here, prosecution witnesses have testified under oath as to your guilt. You are therefore probably guilty, and anything you have to say by way of defense will most likely be a lie. To preserve the sanctity of the oath, we put the possibility of perjury out of your reach by declaring you not competent as a witness. Now, that way of thinking, if you like, was a hangover from the Dark Ages in Europe, when life generally was nasty, brutish, and short, and the preservation of the immortal soul was a driving imperative for most people. But by the late 1800s, with the onset of the Age of Enlightenment, that way of thinking was long past its shelf life. Now, there were those who argued thus: if the law forbade the accused to be a witness in his own defense, the burden falls that much heavier on the prosecution. If the accused is allowed to testify, a jury is likely to decide whose version is more likely to be true on a mere balance of probabilities. Now, this argument, of course, is specious, as Wilmington against the DPP shows. The prosecution still has to prove, in the light of all the evidence, including that of the accused, whether he's guilty beyond a reasonable doubt. Lord Hornsby's Act, the Criminal Evidence Act of 1898, established the framework of the modern criminal process. By that act, an accused person got the right to testify in his own defense, and there were safeguards in his favor. His failure to testify cannot be made the subject of comment by the prosecution. Previous convictions for other offenses cannot be put to the accused unless closely related to the charge. His character was not in issue unless he has put allegations of bad character to prosecution witnesses. Now, all these factors are in place in the law today. As can be seen, the human rights content in the English common law started from a very low base. Now, if one went back 200 years, the scene was dire. The concept of a fair trial was very different from that of today. Now, in 1800, there were 160 offenses punishable by death. And sheep stealing was one, though in many such cases, transportation to the far-flung colonies was substituted for the death sentence as an act of mercy by the king. And it's ironic that some Australian families grown rich on the export of wool should trace their origins to sheep stealers in England. Now, fair trial is a broad concept. Apart from protection of the innocent, it mandates the conviction of the guilty. Fairness of the community so requires. Fair trial is a process which begins with investigation and terminates with acquittal or sentence. A confession, if true, is the best possible form of evidence in the proof of guilt, but for the evidence to be admissible, the law requires the prosecution to prove its voluntariness. Thus, a confession extracted by waterboarding, for instance, would never be admitted into evidence. Now take the subject of entrapment, which has given rise to much case law. It often involves an undercover police operation. Let us say that there's a known drug dealer, but his customers refuse to testify against him. So a police officer in plain clothes, pretending to be a drug addict, goes to him and buys a quantity of drugs. Here, as can be seen, all the elements of the crime of dealing are complete and there can be no defense. Of course, if the dealer had known that the buyer was a police officer, he would never have entered into the transaction. So in a sense, it can be said that the accused was deceived or entrapped into selling the drugs. But the House of Lords, in the Queen against Sang, S-A-N-G, held that there was no defense of entrapment known to English law. What if the person approached by the undercover police was not a dealer, just an ordinary addict with a quantity of heroin for his own use? Assume the police offers him money for the drugs and he says no. The police offers more money to overcome his refusal and eventually he succumbs and sells the drugs. Again, all the elements of criminal dealing in drugs are complete, but here the police officer was not just acting as an ordinary buyer, he had in effect instigated the crime. Upon the principle laid down by the Queen against Sang, this would still not have afforded the accused a defense, but would be relevant in mitigation of sentence. In essence, the court is not concerned as to how evidence is obtained. It is not the business of the courts to discipline the police. As Lord Fraser engagingly said in The Queen Against Sang, when Adam and Eve ate of the forbidden fruit, and Eve proclaimed, "But the serpent beguiled me," they were evicted from the Garden of Eden just the same. Now, what if the prosecution of the accused involved gross violation of his human rights? The Queen against Horseferry Road Magistrates Court ex parte Bennett was one such case. There, a New Zealand citizen, Bennett, alleged to have committed crimes in England, was traced to South Africa. There he was forcibly abducted and brought back to England for trial. Now, this was a gross violation of South African law. It was an abuse of executive powers. It tarnished not only the investigation, but tainted the entire legal process. And the court treated it as an abuse of its own process, and reasoning that the court had inherent jurisdiction to prevent such abuse, ordered the prosecution to be stayed. As can be seen, the Bennett case departed from the rationale of the Sang case to an extent. If it was no business of the courts to discipline the police, why was the way that Bennett was brought to England for trial relevant? Well, there was this difference. The Sang case concerned the gathering of evidence against the accused, but in the Bennett case, a basic human right of the accused was involved, the inviolability of the person. In the Hong Kong context, a guaranteed right under Article 28(1) of the Basic Law. The protection of that right trumped the community's interest in having the accused Bennett tried in England, be he innocent or guilty of the crime alleged. Now, a fair trial is a disciplined process, effectively and speedily concluded as required by Article 11(2)(c) of the Bill of Rights. By far, the largest number of prosecutions take place in the magistrates' courts in Hong Kong. It is here, above all, that the ordinary citizen comes face to face with the criminal law. These are courts of summary jurisdiction, bound by the four corners of the magistrate's ordinance. A magistrate's duty when a charge is laid before him or her is to deal with the whole matter as set out in the charge, nothing else. And after having heard the whole matter, to acquit or convict the accused. This is clearly set out in section 19(2) of the Magistrates' Ordinance. A magistrate has no jurisdiction to determine constitutional issues. If an accused should raise a challenge to the statutory provision contained in the charge sheet, the magistrate's duty is simply to say to him, how do you plead guilty or not guilty to the charge? If the accused declines to do that, the magistrate should simply record the plea as not guilty and proceed with the trial. A constitutional challenge is wholly outside the scope of the magistrate's ordinance. Now, what precisely is a constitutional challenge, quote unquote? Take a common case. The registered owner of a car receives a police notice saying that the driver may have committed an offense by speeding through a red light. The notice, served under Section 63 of the Road Traffic Ordinance, requires the registered owner to give particulars of that driver. He fails to comply and is prosecuted under that section. Can the accused raise a defense by alleging that Section 63 is unconstitutional? No, of course not. There's a strong presumption that a statute standing in the statute book is valid in every respect, be it the Road Traffic Ordinance, the Magistrates Ordinance, the High Court Ordinance, or any other ordinance. Now, were it otherwise, the whole system breaks down. As Mr. Justice Ribeiro said in Secretary for Justice against Yao Yuklong, Zigo, and another, quotes, a decision that a statutory provision is unconstitutional is of the gravest import and generally cause for examination by the higher courts, unquote. Now, this is more than a matter of judicial policy, it is one of jurisdiction. A magistrate has no jurisdiction to determine such issues, full stop. When counsel submits a statutory provision is unconstitutional, say Article 63 of the Road Traffic Ordinance, he or she can dress up the submissions in page after page of text, citing numerous cases from the European Court of Human Rights. They still remain just words. Words of such have no bite. A court of law is not a talking shop where people exchange ideas and perhaps show off their learning. It is only when the pronouncements of a court can be rendered into an enforceable order that words have teeth. Now, how do courts do that? They act in this way. When a matter is considered in the High Court, the judge determines that a statutory provision is unconstitutional, he or she makes a binding declaration of right to that effect. This is authorized by Order 15, Rule 16 of the Rules of the High Court, which says, quotes, the court may make binding declarations of right, whether or not any consequential relief is or could be claimed, unquote. Now, when such a form of relief is ordered by a High Court judge directed at, say, the Commissioner of Police as respondent in legal proceedings, the Commissioner is bound by the order and must in turn ensure that Section 63 notices should no longer be issued and all proceedings in reliance on such notices should be stayed. That is because a court of competent jurisdiction has in effect so ordered by making a binding declaration of right. This would then have wide implications for road safety generally. The entire community is affected, not just the accused in the dock. Order 15, Rule 16 of the Rules of the High Court has no application in a magistrate's court. Declaratory relief is simply not available to magistrates. When an accused appears before a magistrate on a criminal charge, the only party before the court is the accused himself, no one else. But a declaratory judgment concerns not just the accused, it affects the whole community. To be valid and effective, it must be directed at the authority concerned, say, the Commissioner of Police in relation to a Section 63 notice. But the Commissioner of Police is not a party to the charge before the magistrate for failure to comply with a Section 63 notice. So how could he be bound by a pronouncement made by a magistrate when dealing with such a charge? Furthermore, the magistracy is not a unitary court such as the High Court. There are 7 magistracies in Hong Kong, What if the Shatin magistracy says that Section 63 of the Road Traffic Ordinance is valid and constitutional? Is valid and constitutional, but the Fanning Court says no. These obvious points of common sense have been repeatedly overlooked in proceedings in Hong Kong over the past 20 years. Magistrates in the exercise of their criminal jurisdiction have assumed a constitutional role unchallenged, which they never lawfully possessed. Now, Secretary of Justice against Latker, L-A-T-K-E-R, decided in January 2009 was exactly such a case. It concerned a prosecution in a magistrate's court for non-compliance with a Section 63 notice. When asked at the end of the prosecution case what he had to say, the accused said that the matter was one of principle and he would be guilty of, quotes, civil cowardice, unquotes, if he agreed to provide the particulars of the driver as required. Now, that was the sum total of his case. The magistrate, instead of proceeding to find the defendant guilty as charged, adjourned the proceedings. 3 months later, he gave his so-called verdict, comprising 53 pages, ranging widely over European human rights case law, in which he held that Section 63 of the Road Traffic Ordinance contravened Article 11 of the Bill of Rights and dismissed the charge against the accused. The Secretary of Justice appealed. When the matter eventually reached the Court of Appeal, the provenance of the case in the magistrate's court was forgotten. The fact that the magistrate had delivered no viable verdict on the charge before him and had no jurisdiction to make the pronouncement as he did on Section 63 was simply ignored. The Court of Appeal rejected at the outset the magistrate's finding that Section 63 breached Article 11. Rightly so, for that finding was totally absurd. But, said counsel, what about Article 10? No, it was equally absurd, but the court, instead of rejecting this outright, took it on board. Now, this is what Article 10 says, quotes, all persons shall be equal before the courts and tribunals. In the determination of any criminal charge against him or of his rights and obligations in a suit at law, everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law, unquote. Now, how, one might ask, was Article 10 engaged at all in a case like that? The expression, a criminal charge, quotes unquote, in Article 10, is probably one of the most used words in the criminal law. Its meaning has never been in doubt. But one of the justices of appeal said, no, in the context of European human rights law, it could have an autonomous meaning, quote unquote. The Section 63 notice issued to the registered car owner seeking information from him could be construed as a charge against him. By this piece of forensic alchemy, magically turning lead into gold, the court concluded that Article 10 of the Bill of Rights was engaged. This led the court to a wide-ranging examination of European human rights case law. The provisions of Section 63 were stripped apart and examined piece by piece. The whole exercise covered tens of pages, mired in obscurity. The court concluded at the end of the day that Section 63 was, after all, proportionate and constitutional. The magistrate's so-called verdict was quashed. The matter was returned to the magistracy. Now, what else could the magistrate then do except to convict the accused as charged? Now, what should have been a simple enforcement proceeding in the magistracy was turned into a constitutional drama, a carnival of words, which achieved nothing except to tarnish the rule of law and achieve a gross delay in the ultimate result, and it is an open invitation to those minded to work mischief in the courts. This foray into obscuranticism led by counsel is symptom of a deep malaise. It is denial of the effective and vigorous implementation of the policy of one country, two systems. It would be rare that a real systemic fault is found in a statutory provision, in which case the High Court would of course be bound to give it serious consideration. Now, the Attorney General against Lee Kwong-kat was such a case where the Privy Council struck down Section 30 of the Summary Offences Ordinance for its structural defect, holding that it conflicted with the presumption of innocence in Article 11.1 of the Bill of Rights. At the same time, Lord Wolfe, who gave the judgment, sounded this warning, quotes, "It must not be forgotten that decisions in other jurisdictions are persuasive and not binding authority, that the situation in those jurisdictions may not necessarily be identical to that of Hong Kong. This is particularly true in the case of decisions of the European Court of Human Rights," unquote. And he followed up with this general advice. Whilst the Hong Kong judiciary should be zealous in upholding an individual's rights under the Hong Kong Bill, it is necessary to ensure that disputes as to the effect of the bill are not allowed to get out of hand. The issues involving the Hong Kong Bill should be approached with realism and good sense and kept in proportion. If this is not done, the bill will become a source of injustice rather than justice, and it will be debased in the eyes of the public, unquote. Now, Lee Kwong-kat was decided in 1993. Since that time, the balance between individual rights and community interests has gone totally out of kilter. Time and time again, under the urgings of counsel, courts have allowed personal rights to overwhelm societal interests to the extent that it can produce judgments like that in the face mask case decided in November 2019, where at the height of a deadly insurgency with police resources stretched to breaking point, a high court, in a 100-page judgment, could think it right to put the interests of a tiny minority, the LGBTQI community, above public safety. Now, surely a case like Latka's should lead to at least one thing, that the first act of judgment to be exercised by a court is to determine whether a real case of concern is raised or whether the courtroom is simply being made into a platform for grandstanding. In Latka, the Court of Appeal could have shown leadership and knocked the matter on the head, giving no oxygen to fatuous submissions. The face mask case preceded the national security law. Now, has there been a shift since then in the culture of the judiciary? Has there been a reset in the balance between individual rights and community interests? It is perhaps too early to tell, but there are encouraging signs, such as the judgment in the Tong Ying Git case decided in July this year by the High Court. A judgment solidly founded on the facts and surrounding circumstances of the case, resting on straightforward common law principles. It would have been easy for the court to be diverted or beguiled into comparative jurisprudence, to discussion of European human rights case law or the 1984 Syracuse principles, as so often has happened in past cases, as exemplified only by the Latka case. It is refreshing to see that none of that took place and the court came out with a judgment in the Tong Ying Git case, which most people would have understood. It was transparency in practice in the true sense. If that indicates a fresh approach to human rights concerns by the judiciary, in enforcing the criminal law, that would be a new dawn for the community. In every major institution in the world, when something has gone radically wrong, there is an internal audit, a quality assurance exercise, perhaps a reset in values to ensure that the same thing does not happen again. Is this what has happened in the judiciary? Well, I fervently hope so. Thank you for your attention.
We thank Justice Lytton for sharing his views with us. He emphasizes that the keywords are a fair trial, but he recognizes that there are different shades of interpretation as to what that concept entails. He mentions that a fair trial is a broad concept, and apart from the protection of the innocent, it mandates the conviction of the guilty. He highlights that a court of law is not a talking shop. It is only when the pronouncement of a court can be rendered into an enforceable order that words have teeth. In his view, it is rare to have a systemic fault in a statutory provision. But when there is one, the High Court will be bound to give it a serious consideration, such as the case of Lee Kwong-Kut, decided in 1993. Finally, Justice Lytton comments on how the court should have struck a balance between the accused's personal right and the broader societal rights. Our next speaker, if I may introduce, is Mr. Benjamin Yu, Senior Counsel. Benjamin was admitted to the Hong Kong Bar in 1979 after obtaining his Bachelor of Laws degrees, First Class Honours, and PCLL at the University of Hong Kong. He started practice in Hong Kong in 1981 after obtaining his master's degree from the London University. He took silk in 1995. He has served as Deputy High Court Judge and as Recorder of the Court of First Instance in Hong Kong. He is currently in practice as Senior Counsel, and he frequently appears as counsel for the Hong Kong SAR government in constitutional law and public law cases. He was a member of the Law Reform Commission from 2004 to 2009, and held various chairmanships and memberships of government committees and advisory bodies. He was awarded the Silver Bohemia Star in 2009. He is a visiting professor honorary of the Law Faculty of the Chinese University of Hong Kong. Benjamin, the floor is yours.
Ms. Lam, Secretary of Justice, distinguished guests. My topic today, human rights consideration in criminal law context, seeks to map how the court really strikes a balance between individual rights and societal interests. Now, our basic law guarantees fundamental rights. And those guarantees, which are well known in the basic law, includes, for example, freedom of speech, freedom of association, assembly, or procession, demonstration. But you can see from the wording of the basic law, for example, Article 27, that those rights belong to the individuals. So it says Hong Kong residents shall have freedom of speech, the press, etc. So we are dealing here with individual rights when we are talking about fundamental rights. Criminal law, on the other hand, is concerned with societal interests. That's the protection of society. And such laws would typically involve restriction on the conduct of individuals. Thus, one often finds a tension or conflict between the rules in the criminal law statute, which aim to protect society as a whole, on the one hand, and fundamental rights and freedoms enshrined in the basic law on the other. So whenever there's a conflict, one can conceive of a challenge. And the challenge to the criminal law, whether it's criminal statute, regulation, or even the crime at common law, will have to be dealt with by the courts. Now, how are such challenges to be made? There are two types of challenges. One can call systemic, and Justice Lytton referred to that just now, when you are challenging the constitutionality of an ordinance or a piece of legislation, whether primary or subsidiary, or the crime in common law, you will be embarking upon what is called systemic challenge. Now, that is to be distinguished from what is called an operational challenge. And the operational challenge involves challenging an actual decision by the administration or the law enforcement agency. Now, to embark upon a systemic challenge, one has first to identify the constitutional rights engaged in the either basic law or the Bill of Rights. And you ask whether the provision in question restricts any such right. In many cases, more than one fundamental right may be involved. Justice Lytton just now referred to the what he called a face mask case. And one can see in the face mask case that there are actually quite a number of different rights which are engaged. And you can think of rights such as the freedom of expression, freedom of assembly, freedom of demonstration. These are, and also the right to privacy. And these are all engaged when there is a provision in the prohibition against facial covering regulation to restrict the right of a person who is engaged in a public assembly or public procession to wear a face mask when you are demonstrating. Now, so having then first identified what's the right engaged, and you then ask whether the regulation or the law in question restricts those rights. And assuming that your answer to both questions are yes, there are rights engaged and there's restriction, the next question which you ask is whether the rights are absolute or whether the rights are subject to restriction. There are rights which are absolute, and in the Court of Final Appeal case in Ubamaka, Ubamaka, Justice Ribeiro pointed out that the right not to be subjected to torture or CIDTP, that's cruel, inhuman, or degrading treatment or punishment, is not derogable. In other words, it's absolute and cannot be the subject of restriction as an internationally accepted standard. So that's the kind of right which is held by the Court of Final Appeal to be absolute, not capable of being restricted. But most rights which you find in the basic law or the Bill of Rights are not absolute and are therefore capable of being restricted. And the restriction, of course, has to be tested and tested by first a requirement of legality, that it must be what is called prescribed by law. And secondly, it must satisfy what is called a four-stage test. The requirement that any right or regulation that restricts fundamental freedom must be prescribed by law is constitutionally enshrined in Article 39, Subarticle 2 of the Basic Law, which reads, "The rights and freedoms enjoyed by Hong Kong residents shall not be restricted unless as prescribed by law, and such restriction shall not contravene the provisions of the preceding paragraph of this article." So prescribed by law is important. It is a manifestation of what is called the principle of legality. And it boils down to the idea that any restriction of fundamental rights must have some basis in domestic law and must be sufficiently clear and accessible. Now, accessible is not difficult to understand. It means that it is publicly accessible. A person will be able to find out what the law is. The concept of the certainty of the law is a more difficult question, because the degree of certainty required is not absolute certainty, but rather that the criminal offense must be formulated with sufficient precision to enable the citizen to foresee, if need be, with appropriate advice, whether his course of conduct would be lawful or unlawful. And there have been quite a number of Court of Final Appeal cases on this question of prescribed by law as to whether the law in question is sufficiently certain to be a lawful restriction of the fundamental rights. In the case of Mo Yuk-ping, Sir Anthony Mason, our very renowned and respected permanent judge, said it is, however, accepted that absolute certainty is unattainable and would entail excessive rigidity. Here it is recognized that a prescription by law inevitably may involve some degree of vagueness in the prescription, which may require clarification by the courts. The concept of legal certainty recognizes that in a common law system, the common law declared as it is by the judges involves an incremental element of judicial lawmaking, whether by way of molding the law to meet new circumstances and conditions, or to correct errors of principle or doctrinal error. In any event, with a common law, as with the interpretation of statute law, it is inevitable that questions continue to arise which require clarification by judicial decision. That is one reason why absolute certainty is unattainable and why some degree of vagueness is inherent in the formulation of laws, especially laws expressed in general terms. You can see that in the context of particularly common law crimes, such as conspiracy to defraud, that's the Mo Yuk-ping case, such as the law against Champati, that is the Winnie Low case, or the law against the misconduct in public office, that's the Sham Kok Share case. All these are decisions of the Court of Final Appeal. The court had to grapple with the notion that this is a common law crime, that, as we all know in common law, the law progresses incrementally on a case-by-case basis, and it is not laid down in a code, such as a crimes ordinance or summary offences ordinance, where you can see the limits of the rule. There is obviously an inevitable tension between requiring a law to be formulated with sufficient precision and the desirability of avoiding excessive rigidity in the law. And it is always said that the appropriate level of precision must depend on the subject matter of the law in question. On the prescribed by law requirement, there was an attempt in the Kok Wing Hung case, that's the face mask case, to argue that the ordinance, that's the emergency regulations ordinance, does not satisfy the requirement. For those who are familiar with the subject, you will know that that ordinance was passed way back in the early 20th century to deal with strikes. And it empowered the what was then the Governor in Council to pass emergency regulation in times of emergency or public danger. And that ordinance, which is a relatively short piece of legislation, was called to the aid of Hong Kong in the period in 2019 when the CE in Council made the prohibition against the facial covering regulations. And in the face mask case, the challenge was a systemic challenge, both on the ordinance, the emergency regulation ordinance, as being unconstitutional, and also on the regulation which was made by the CE Council in October 2019, the prohibition against face mask regulation as unconstitutional. And in the particular argument in that case, it was said that, well, the ordinance itself was unconstitutional because it grants an extremely wide power to the CE Council to make regulations in times of emergency or public danger. And that violates, it was argued, the prescribed by law requirement. Now, the Court of Final Appeal held in its judgment that the requirement was not violated by the ordinance because the requirement is directed at actual restrictions on the rights and freedoms enjoyed by Hong Kong residents. It is not directed at empowering legislation such as the Emergency Regulation Ordinance, which merely authorizes the making of subsidiary legislation, which, if and when made, may seek to restrict fundamental rights. So you can see the challenge was directed at the empowering ordinance, but the empowering ordinance does not by itself restrict rights. It's only where the regulations are made by the CE Council when the regulation would itself restrict the right. So the prescribed by law requirement, if satisfied by the regulation, will mean that the restriction on fundamental rights is prescribed by law, and there's no need for the emergency regulation ordinance, which is the empowering ordinance, to satisfy that requirement. So the first step is the prescribed by law, and the next step, which requires really a four-stage test, is the proportionality. Now, this is a concept which we imported from the European jurisprudence, from human rights. For those who practice or have any engagement in public law, you will know that in public law we have a concept of when be unreasonable. What does that mean? And the well-known case is the Wednesbury case itself, where Lord Green gave an instance to say that, well, if somebody has made a decision on the basis that the particular applicant has red hair, it's got nothing to do with the decision, then of course it's Wednesbury unreasonable because it is irrational. It takes into account something which obviously should not be taken into account. So that's the public law concept of Wednesbury unreasonable. Now, proportionality is a more demanding requirement. It is not simply a question of, well, is it irrational in the sense that it is perverse, that anyone looking at it would say, well, plainly it cannot be right or reasonable. The proportionality test, since the Heisen decision in the Court of Final Appeal, has 4 stages. The first stage is to identify what is the legitimate aim that is served by the restriction. And the legitimate aim, for example, in the face mask case, is the deterrence and elimination of the emboldening effect. That a person who wears a face mask in a demonstration in the time of 2019, there was evidence to show that this has an emboldening effect for people wearing the face mask to partake in violent demonstration, hide behind anonymity, and escape punishment and detection. So that is one of the principal legitimate aim of the face mask regulation. The second is the facilitation of law enforcement, investigation, and prosecution. Now, in the case of a law which prohibits, for example, unlawful or unauthorized possession or meeting, public meeting and public procession. The legitimate aim is the preservation and maintenance of public order. And that was held in the Leung Kok-hong case in 2005. So the first step is identify what is the legitimate aim that the restrictions is supposed to serve. The second requirement is to demonstrate a rational connection between the measure designed to meet the legislative objective and the measure itself. In other words, the measure has to be rationally connected with the aim. This is an objective test. So, for example, if we take the face mask case, the prosecution, or rather the government, does not have to demonstrate that the face mask regulation was actually effective in stemming out people wearing face masks during demonstration. What is to be demonstrated is whether the aim that you seek to achieve is rationally connected with the measure that you are implementing to seek to achieve that aim, and of course, vice versa. So that's the second stage. The third stage is the most difficult one to apply, which is proportionality itself. And what does proportionality mean? Proportionality means that the measure that you adopt to achieve your aim is proportional. And proportional is not a simple kind of a black and white, clear-cut way in which you can test the matter and find your answer. The Court of Final Appeal in the Hyson case mentioned that it is a spectrum ranging from what is called no more than necessary as one end of the spectrum, and the other manifestly without reasonable foundation on the other end of the spectrum. Now, what do those two terms mean? The no more than reasonably necessary means that the measure that you employ to achieve your legitimate aim is not only rationally connected, but is no more than reasonably necessary to achieve that aim. So in other words, it is a pretty stringent requirement compared to the other end of the spectrum, which is manifestly without reasonable foundation. And that is rather similar to what's called the Wensbury test. In other words, that it is such that it is manifestly, so very obviously, without a reasonable foundation. Now, which particular end of the spectrum, or somewhere in the middle of the spectrum, would the court adopt to test proportionality depends on a number of factors, such as the question of what is the nature of your right in question, the degree of the interference of the right in question, and the identity and the constitutional role of the decision maker. So it's why that is a difficult test to apply in practice. In terms of understanding the proportionality test is not difficult, but applying it in a particular case are difficult. Now, in the face mask case, again, using that case as an illustration, there were restrictions in regulation number 3 of section 3(1)(a), B, C, and D of the regulation to different types of assembly. And there are 4 types. One is section 3(1)(a), which is a prohibition that a person may not use any facial covering that is likely to prevent identification while the person is an unlawful assembly, whether or not the assembly is a riot within the meaning of section 19. So section 3(1)(a) is dealing with unlawful assembly. Section 3(1)(b) deals with unauthorized assembly. And section 3(1)(c) deals with a public meeting that is not within either paragraph A or B, and D is dealing with a public procession that is not within either A or B. Now, I won't go into the details of those, but very simply or briefly, what these are dealing with is basically first a category of unlawful assembly. And unlawful assembly are assemblies where there is either violence or threat of violence. Unauthorized assembly are assemblies such as procession or meeting where the organizer has either not applied to the Commissioner of Police for a letter of no objection, or he has applied, but the Commissioner does not grant a letter of no objection. So those are the unlawful and unauthorized. And then C and D are basically those which are authorized, but those could be a situation where a gathering or assembly takes place even after the Commissioner of Police has issued a letter of no objection. Now, in the face mask case, it was accepted by the applicants that the prohibition against wearing a face mask is proportionate in the case of unlawful assembly. In other words, they accept that in a case where there's an assembly which is violent or there's a threat of violence, they accept that prohibition against wearing face masks is not reasonable, is no more than reasonably necessary, right? Now, but they say that the prohibition of wearing a face mask in the case of an unauthorized assembly, one where there is no threat of violence, but where the Commissioner of Police has either not been asked to give a letter of no objection or where the letter of no objection is declined, they say that because it is a peaceful demonstration, then prohibition against face masks would be disproportionate. And for the last two categories, C and D, which is basically authorized procession or assembly, they say that is plainly disproportionate. Now, in the Court of Final Appeal, the Court of Final Appeal held that the flaw in the submission, which is to distinguish between a procession or a meeting, a public meeting that was eventually found to be peaceful and no violence or no threat of violence. The Court of Final rejected that submission on the basis that there was the flaw in that the legitimate aim to which the prohibition is directed is not limited just to public gatherings at which violence has already broken out or where an identified criminal offense under public order ordinance has already occurred. As they have noted, the prohibition against facial covering regulation has a twofold aim, both to deter violence and crime and to promote effective law enforcement. Inherent in these legitimate aims is the fact, as the events in 2019 in Hong Kong show, large demonstrations are fluid events which can be difficult to control and police. What may start as a peaceful demonstration may readily degenerate from a peaceful gathering into a serious public order incident involving hundreds or even thousands of people. The preventative and deterrent nature of the prohibition against facial covering regulation is therefore crucial. Now, that is a very important decision, not only in the context of 2019 Hong Kong, that people now have gone through that period, but it also signifies that when the court considers proportionality, the court has to consider not something which is theoretical, not something which is plucked from a case in a particular context, say in some jurisdiction in Europe, but the court is concerned with actual reality in Hong Kong. And what is important is that in 2019, if an organizer purports to organize a public procession or public meeting, and he knows that the Commissioner of Police doesn't grant a notice of a letter of no objection, which means that the Commissioner effectively is objecting to the holding of the public meeting or the public procession, then there was certainly in the 2019 era a very clear risk that the hitherto peaceful demonstration will break out into a violent demonstration. And the prohibition against facial covering regulation has to be seen in that context, and the legitimate aim has to be seen in that context. The regulation, of course, was enacted by the Chief Executive and Council at a time where there was, to quote and unquote, an alarming breakdown of law and order and escalating violence, with multiple outbreaks of violence which happened simultaneously in Hong Kong, and many episodes of violence outbreaks from public gatherings that may have initially been peaceful. Another point made by the Chief Court of Final Appeal is that the wearing of facial covering, whilst it may be a legitimate form of expression to be used for reasons of privacy or a legitimate desire for anonymity, does not lie at the heart of the right to peaceful assembly. The prohibition does not therefore strike at the core of the fundamental right. Just now you've heard from the talk by Mr. Justice Lytton that at first instance, the court allowed a right of very minority, the LGBT, really to trump society interest. And perhaps as a footnote to explain that the argument advanced on behalf of the applicant in that case to argue against the constitutionality of the prohibition was that there are people who have a legitimate reason to want to wear a face mask during demonstration. And the instance which was actually given was the LGBT group, that they don't want to be stigmatized, they don't want to be able to be identified as persons who associate with the LGBT rights, and they would have their right to march the streets and carry the banner without the risk of being identified. Now that, of course, is a right which is within the guaranteed right of freedom of expression and the right to privacy. No doubt about that. That is a right. But what Justice Lytton was referring to was that that right was allowed to trump societal rights in the judgment of the first instance. And in the Court of Final Appeal, that was reversed, because the Court of Final Appeal makes the point that although it is a manifestation of your freedom in terms of freedom of expression, in terms of right to privacy, not to be required to go in the street with your face bare, but to protect your face by a facial covering, that is not at the heart of the right to peaceful assembly. In other words, you can still exercise your right of peaceful assembly without wearing a face mask. So that is the point. Now, in the Court of Final Appeal, there was also argument as to whether the intensity of review should be at the manifestly without reasonable foundation end of the spectrum, or the no more than reasonably necessary end of the spectrum. And in the Court of Appeal, rejected the government's argument, and the Court of Appeal found that because we are concerned with such a fundamental right, the court is in as good a position as the Chief Executive Council to decide where the balance should be struck. And the court then held that the correct threshold is no more than reasonably necessary. The Court of Final Appeal left the question open. They didn't actually say one way or the other whether the Court of Appeal was right or whether the government's argument was right. And instead, the Court of Final Appeal cited a dictum from Madam Justice McLaughlin in the case of R.J.R. McDonald, a Canadian Supreme Court case, where Her Ladyship said that if the law falls within a range of reasonable alternatives, the courts will not find it overbroad merely because they can conceive of an alternative which might better tailor objective to infringement. On the other hand, if the government fails to explain why a significantly less intrusive and equally effective measure was not chosen, the law may fail. Now, I think a law student will find this extremely difficult. Indeed, it would not be easy even for a practitioner, because if the test is no more than reasonably necessary, you would think that, well, if I can think of an alternative way of restricting the right, which does not violate the human rights as seriously as the measure in question, then of course the measure in question should be struck down. No, that's not what the Court of Final Appeal said. The Court of Final Appeal adopted that principle by the Supreme Court of Canada, that if the law falls within a range of reasonable alternatives, the courts will not find it overbroad. So one can see that you can't just apply the test very literally. You have to look at really the context and apply it in the context of the case. The step 4, the last step in the proportionality analysis, is a test which was adopted by the Court of Final Appeal in the Heisen case, which is that at the end of having applied all 3 tests, you then have to, as it were, stand back and look and ask whether a fair balance has been struck. And this requires the court to take an overall balanced view. Now, in the Heisen case, Justice Ribeiro pointed out that in the great majority of cases, the application of the 4th step will not invalidate a restriction which has satisfied the requirements of the first 3 stages of the inquiry. Now, that is simply an observation to say that if you actually pass all 3, you are very likely to pass the 4th. But that doesn't mean that you don't have to go through the 4th. You still have to ask and stand back and look whether there's a fair balance struck. But what is particularly helpful in the Court of Final Appeal judgment in the face mask case is that the court noted how the court's approach as to how they apply the fair balance test is useful, because they noted that the prohibition against facial covering affects a range of people in Hong Kong. Although some people might wish to demonstrate in public, but with a facial covering as a form of expression or for reasons of privacy. So that's one class of person, like the LGBT group, or people who say they're employees and want to march in the street about employees' rights and are afraid to be identified by their employer. So that is one class of person who want to demonstrate in public, but with a facial covering as a form of expression or for reasons of privacy. The court then said there are others who might wish to demonstrate peacefully, but who were deterred from doing so because of the ongoing violence. Now, in the context of 2019, that is a perfectly valid point. In other words, if you cast your mind back to 2019, when there were outbreaks of violence practically every day, if not every week, if not every day in Hong Kong, in the streets of Hong Kong, everywhere in Hong Kong, where there's either violence or potential violence. Now, for some people who say, I want to demonstrate against a cause, whatever that cause may be, he or she may be deterred from actually exercising that right and going on a peaceful demonstration, because he or she genuinely fears that going on the street may involve me embroiled in some violence, and he or she doesn't want either to be caught up with the law or be seen to be endorsing the acts or the antics of those who engage in violence. So there are this class of persons who have to be considered. And then the Court of Final Appeal said the interest of that latter category should be given due weight in the balance. Similarly, due weight must be given to those persons who have sustained personal injury or property damage as a result of the actions of the violent protesters. So that is another class of persons which society have to bear in mind. I'm sure you remember there were shops fronts which were broken, was set alight by protesters, and those people suffered the damage to the property, and some even suffered personal injuries as a result of the violent acts of others in the period of the time. So those are all the matters that one has to consider. And finally, the interests of Hong Kong as a whole should be taken into account, since the rule of law itself was being undermined by the actions of the mass law breakers, who, with their identities concealed, were seemingly free to act with impunity. The Court of Final Appeal, as in fact both the Court of Appeal and the Court of First Instance, all three courts were treated to that argument on behalf of the government, that the way in which we find ourselves in 2019, where protesters wear face masks, the black cat costumes, and they basically go on a rampage in the streets. They are filmed daily on television, live television broadcasts, the homes of Hong Kong. That is actually a very severe damage to the rule of law in Hong Kong, because the signal to the Hong Kong residents at the time was that it's okay to do violence because you can get away with it. And you can see from the judgment of the Court of Final Appeal, where they apply this fair balance, they are very much alive to the realities of Hong Kong and the societal interest in terms of the protection of community interest. And the rule of law is, in fact, has suffered a severe beating in 2019. So you can see that when it comes to balancing individual rights against the interests of society, it is always a difficult act to balance. And the Court of Final Appeal, in the series of cases in human rights context in criminal law, devised these measures of testing whether it's prescribed by law and the proportionality analysis to ensure at the end of the day that a fair balance is struck between the rights of the individual and the interest of the community. And one can see that it is not a kind of dry and sterile topic, and that you can just, as has been very often done, cite a particular dictum from a European case or even a South African case or some other jurisdiction, and then say, well, it applies in our jurisdiction. That is, in most cases, very unhelpful, because at the end of the day, the balance has been struck in the context and in the interest of our society. Thank you.
Thank you, Benjamin. Ladies and gentlemen, I'm conscious of the time, so I'll just go straight to introducing our last speaker of the session, Mr. Johnny Mok, Senior Counsel. Johnny is a practicing barrister in Hong Kong. He is currently a member of the Vu Chambers in Hong Kong and Brick Court Chambers in London. He was appointed Senior Counsel in 2006, and in 2008, he became a member of the Committee for the Basic Law of the Hong Kong SAR, which is an advisory body under the National People's Congress of the Republic of China. Johnny was appointed a Justice of the Peace in 2013 and was awarded a Bronze Bohemia Star in 2016. Johnny's practice is focused on cases having a public dimension, which include public inquiries, applications for judicial review, regulatory and administrative hearings, and appeals. Many of these involve issues of constitutional and administrative nature. Johnny is regularly instructed to advise and represent the governments of the Hong Kong SAR and the Department of Justice. He is co-author of a book entitled Judicial Review in Hong Kong. Johnny will be delivering a speech entitled Problems in the Application of Human Rights Considerations in the Criminal Law Context. Johnny, please.
Thank you, Ms. Lam. Secretary for Justice, ladies and gentlemen. Most people, myself included, when they conduct legal research, particularly in relation to a case, only focuses on a judgment which is delivered by the highest court, maybe the CFA or the CA, and rarely the lower courts or the courts of first instance. Now, this is unfortunate because in my experience, sometimes you learn more from the cases that have been overruled than the cases that actually set the decision right. And I learned myself in the hard way in the first year of my law school when I was given the first test in contract law. It was a problem question. I did the problem, but ended up making a lot of mistakes. And luckily, on that occasion, we were all given the model answer. So what I did was that I actually spent a lot of time comparing my own answer to the model answer. And as a result, I actually discovered what I consider and that has been very helpful to me throughout law school as the proper way to study law. Now, this is the approach that I intend to take today on my topic. Now, Mr. Yu has helpfully expounded on the topic of this session, which is human rights considerations in the criminal law context, by reference to the relevant principles of public law, which are well established to analyze these matters. These principles are tools used by the courts to weigh the legislative or executive measure which restricts a fundamental right, backed by criminal sanctions, against the aim sought to be achieved by such measure. At the end of the day, what the courts do is to seek to strike a proper balance between individual and societal interests on the one hand, and the law enforcement objectives on the other. Whilst these principles and tools are well established, they are not necessarily easy to apply in practice. My task, therefore, is to examine more closely some of the problems that a court may encounter in applying such principles in actual cases. And I have chosen 3 recent cases which I was involved in to illustrate such problems. The first case is Sham Wing Can against the Commissioner of Police, decided by the Court of Appeal on the 2nd of February last year. The subject of that case was the right to privacy. In particular, the privacy attached to the vast volume of personal information, including private communications contained in a person's mobile phone, which was seized by the police pursuant to its power upon arrest of a suspect without having first obtained a search warrant. The Court of First Instance, the CFI, ruled that in order for the power of warrantless search incidental to an arrest to be exercised on a mobile phone, pursuant to Section 50, subsection 6 of the Police Force Ordinance, the police need to show that there are, quote, exigent or emergency circumstances, unquote, to justify such search without obtaining a warrant. The exigent circumstances are those where an urgent search, the word is urgent, may A, prevent an imminent threat to the safety of the public or police officers, prevent an imminent, so the word is imminent, B, prevent imminent loss of or destruction of evidence, again the word is imminent, or C, lead to the discovery of evidence in extremely urgent and vulnerable situation. The operative term is extremely urgent and vulnerable situation. The reason for importing the exigency requirement is, according to the CFI, 1, the high importance of protecting the massive and extensive personal information and data, and 2, the need to give meaningful effect to the constitutionally protected rights to privacy and freedom of private communication against unlawful intrusion. Hence, it is only proportionate to achieve the object of effective law enforcement by permitting warrantless search for the digital content of mobile phones seized on arrest only in exigent circumstances. As noted by the Court of Appeal, this is a categorical approach. That is, the rule to be applied is that a warrant must be obtained before any search of the contents of a mobile phone can be conducted. Exceptions are only allowed where they are shown to be absolutely necessary. Such absolute necessity is encapsulated in the term exigent circumstances, and there are principally only three of these circumstances, namely the three that I have summarized. Reduced to its basic elements, this approach treats the fundamental rights to privacy as an overriding interest, and as such, it should be protected unless it can be shown to be absolutely necessary to restrict it, particularly in the context of the vast amount of personal information residing in a mobile phone. The CFI found the doctrine of exigency, which was actually borrowed from US and Canadian jurisprudence, to be helpful in defining the circumstances where restriction can be said to be absolutely necessary. Now, the problems with such categorical approach are threefold. Firstly, it ignores the practical considerations which make the approach difficult to apply in many situations. Secondly, it fails to distinguish between different purposes for conducting the search in different cases, which would give rise to different levels of privacy intrusion or privacy interest. And thirdly, it fails to have regard to the origin of the exigency doctrine, which is incompatible with the purpose of the common law power of search incidental to arrest. Let me briefly elaborate on each of these issues. Firstly, the CFI's approach ignores one basic problem. That is, before inspection of the contents of a phone, it will often be impossible for a police officer to reasonably foretell whether an emergency situation exists or not. This is the famous chicken and egg question. By way of examples, the police officer, without looking at the phone's content, may not be able to tell whether the safety of some other persons will be put at risk, or the evidence in the phone or in a cloud platform will be remotely deleted, or a phone number in a mobile phone's contact or call lists will lose its significance because it will shortly be changed, or an accomplice who had been sent a message to a phone will go into hiding before a search warrant can be obtained, or the phone contains information about another location where the offense would continue or further relevant offense could be committed. These examples demonstrate that the exigency standard requires too much knowledge on the part of the police, but at the same time, such standard gives almost no weight to the law enforcement objectives served by a prompt search incidental to arrest, which encompass the procuring of evidence for the offense for which the suspect was arrested, prevention of loss and destruction of documents, protection of the law enforcement officers and members of the public, and other law enforcement objectives. These are, in short, the basic purposes of procure, prevent, and protect, which underlies the common law power. The second problem exposed by the CA's judgment is that the categorical approach based on exigency makes no distinction between different purposes of the search, which give rise to different levels of privacy intrusion. The Court of Appeal gave the example of a defendant who was observed driving dangerously and erratically by the police. It was suspected that the driver was sending or reading text messages on his mobile phone while driving. In this example, the police were not interested in what the defendant was writing to or reading from another, but with the fact that he was using the mobile phone while driving. On the basis that the discovery of such evidence satisfies one of the law enforcement objectives of the common law power, the Court of Appeal saw no reason why a police officer should not be able to procure such evidence of the commission of the offense or prevent its destruction. Given that not every search of a mobile phone necessarily involves a significant privacy intrusion, the adoption of the categorical approach turns out to be a highly inflexible standard, which again would give almost no weight to the law enforcement objectives underlying the power itself. And such difficulty is exacerbated when the officer may not know precisely what he is looking for in searching the mobile phone, but reasonably believes that it comes within the procure, prevent, and protect purpose which ground the common law power. The third problem of the exigency approach is that it has no regard to the origin of the exigency doctrine, which is actually incompatible with the purpose of the common law power. As the Court of Appeal explained, the origin of the power incidental to arrest was the common law, which is not extinguished by Section 50, subsection 6 of the Police Force Ordinance. This provision is concerned only with procuring evidence, whereas the common law power is directed at wider objectives. Besides procure, prevent, and protect that I have referred to, the common law power also serves other enforcement objectives, such as locating firearms or stolen goods, accomplices, or preventing suspects from evading or resisting arrests. Under both the common law and Section 50, subsection 6, the purpose of discovery of evidence is far wider than what is permitted under the exigency doctrine, and enable police officers to act prudently and promptly in circumstances which may not strictly be characterized as an emergency. On the other hand, the exigency doctrine emerged only recently in the US and Canada in the second half of the 20th century. Of particular relevance is the Fourth Amendment to the US Constitution, which focuses on the need for a warrant before a valid search can be conducted. Such principle has no application in Hong Kong or indeed the United Kingdom. In short, the exigency doctrine fails to give effect to the purpose of Section 50, subsection 6 as regards the discovery of evidence upon a lawful arrest, nor the wider law enforcement objectives underlying the common law power of search incidental to arrest. What this case demonstrates is that sometimes when one applies the principles of proportionality, etc., it is very easy to go for easy solution by reference to purely conceptual analysis without really descending into the details of the matter and to actually discover whether or not a particular solution works or not in actual practice. The second case I wish to discuss is Hong Shui Feng and the Director of Food and Environmental Hygiene, decided by the Court of Appeal on the 16th of December 2019. The human right involved in this case was the right of demonstration. The context was the extensive display of bills and posters by Falun Gong practitioners in various parts of Hong Kong on a regular or permanent basis. Under Section 104, capital A of the Public Health and Municipal Services Ordinance, any person seeking to display such materials on government land has to obtain the prior permission of the director, but the ordinance does not expressly stipulate how such discretion to grant or refuse permission is to be exercised. The applicants accepted that the provision seeks to achieve a general objective, which is to protect the cityscape, balancing the use of public space by different segments of citizens, preventing chaos and conflicts in the competition for such space, and promoting road safety. But they argue that such general object does not provide sufficient guidance to the director on how his discretion ought to be exercised, such that the public can sufficiently foresee how the application for permission will likely be handled. The CFI accepted such argument and held that the provision constituted a restriction on the right of demonstration and as such must be prescribed by law, as my learned friend Mr. Yu has explained. Under this requirement, the provision must not be impermissibly vague. It should give sufficient guide as to how decision is to be reached and should not become an unfettered discretion which deprives the judiciary of the means of controlling the exercise of such discretion. The CFI concluded that as there was insufficient guidance on how the director's discretion was to be exercised, Section 104 capital A falls foul of such prescribed by law requirement. The CA's judgment, setting aside this decision, shows how sometimes it is difficult to apply such a requirement. I wish to highlight just two difficulties here. Firstly, the degree of precision in the formulation of guidance on a particular subject depends on the scope of activities to which the statutory restriction applies. As the Court of Appeal explained, the wider is the range of situations covered by the restriction, the more general the statutory provision would necessarily have to be framed. Here, the restriction on the display of posters and bills on government land covers a wide variety of situations, encompassing a broad range of public places, locations, and duration of display, a large variety of potential users and purposes, many different types of posters giving rise to potentially different environmental and social issues, and the conflict of interest behind a decision permitting or refusing permission to display or affix posters and bills can also vary greatly. And in such circumstances, it is inevitable that the statutory provision has to be worded in a general manner. The CFI adopted an erroneous approach on this point by suggesting that the width of the use to which the power may be put at the discretion of the director means that the guidance by the objects and purposes of the statute alone is insufficient. However, as the CA pointed out, the fact that the power in question covers a broad field of activities ought instead to justify the provision conferring the discretion to be framed more widely and generally. The second difficulty in applying the prescribed by law requirement lies in identifying the relevant law on the facts of a particular case. As the Court of Appeal explained, the proper approach is a holistic one, which has regards not only to the statutory provision in question, but also the common law and even published policies and guidelines. In that case, the Court of Appeal held that three matters in particular provided sufficient guidance on the exercise of the discretion by the director, namely the statutory purpose of protecting the cityscape, a management scheme published by the director, and the common law and constitutional restraints on the exercise of discretion generally. To illustrate how easy it is to miss out one of these relevant sources of law, I refer to the leading case of Hong Kong Television Network Limited against the Chief Executive in Council, which was cited by both the CFI and the Court of Appeal. Amongst other principles, this case mentioned the common law requirement of procedural fairness as being relevant to the question of legal certainty underlying the prescribed by law requirement. This factor is of particular importance in the context of an application for permission, since a fair procedure inevitably means that the applicant should be given proper opportunities to address the decision-maker's concern, a process which would serve to clarify matters which might otherwise remain uncertain from the point of view of the applicant. Rather than recognizing fair procedure as a relevant element providing for legal certainty, the CFI merely confined the Hong Kong television network case to its facts, holding that, quote, what was considered significant there was that fairness required the chief executive in council to give the applicant a fair opportunity of being heard in relation to material matters, unquote. Instead, the CFI relied on a South African decision, which effectively undermines the holistic approach by requiring the statute itself to set out the limit of the discretionary power or guidance on the exercise of the same, and this was corrected by the Court of Appeal, rejecting the South African decision as being inapplicable to Hong Kong. I can assure you that neither myself nor Mr. Yu has anything against South Africa jurisprudence. The third case I wish to discuss is the Secretary versus Leung Kwok Hong, which was decided most recently by the Court of Final Appeal on the 27th of September this year. In that case, Mr. Leung Kwok Hong, then alleged co-members, snatched a folder containing confidential documents from the Undersecretary for Development during a joint meeting of the electoral panels on housing and on development, and passed the document to another alleged co-member for him to read. Mr. Leung was prosecuted for contempt under Section 17C of the Legislative Council Powers and Privileges Ordinance for creating a disturbance which interrupted legislative proceedings. The defense argued that although the words, quote, any person, unquote, are used in Section 17C, it is not applicable to a member of LegCo. This is because, unlike the freedom of speech enjoyed by the public in general, a member's privilege of free speech and debate, which is protected by Section 3 of the ordinance, is an absolute one. And Mr. Leung's offending conduct was the manner in which he chose to exercise his privilege of free speech. The magistrate upheld the defense arguments in a preliminary ruling. Her reason was that any attempt to limit a LegCo member's privilege by an offense of contempt may cause a chilling effect. Thus, when Section 17C is construed against the purposes and objectives of the ordinance, particularly the privilege and immunity enjoyed by a LegCo member in exercising the freedom of speech and debate, the word any person do not include any member of LegCo. Moreover, by virtue of Articles 75.2 and 79.7 of the Basic Law, LegCo has sole control over the conduct of its own members and is well capable of controlling and penalizing, if it so wishes, any disturbance created by its members during the proceedings, and to uphold the dignity of LegCo without external assistance, and how LegCo exercises such power should not be subject to external intervention. The magistrate's preliminary ruling was set aside by the Court of Appeal, whose decision was then upheld by the CFA. As exemplified by this case, a court sometimes regards a right considered to be of fundamental nature as taking precedence, whilst downplaying other provisions in the same statutory scheme which protect other interests or legislative policies. The approach of the appeal courts, particularly the CFA, exposed such a problem and demonstrated how it should be addressed. The CFA began by considering the statutory purpose, which is the starting point of any statutory interpretation. Such statutory purpose, reflected in the long title, includes the provision of a statutory framework aimed at creating a secure and dignified environment in the LegCo complex, conducive to the legislature carrying out its constitutional functions at sittings without disruption or disturbance. Construing a LegCo member's freedom of speech and debate purposively, one must recognize not just the importance of a member's ability to advocate opinions freely and robustly without fear of legal proceedings for such speech, but also the purpose of provisions regulating admission to the LegCo compound and creating offenses which is meant to maintain a secure, a dignified environment in LegCo. The CFA concluded that if it was accepted that the mere participation in LegCo proceedings meant that a member had absolute immunity for his action however and whenever occurring, even if they amounted to a disruption caught by Section 17C, this would be to extend the privilege of free speech and debate beyond the purpose for which it is granted. Thus, giving effect to the statutory purpose, the court held that, whilst the limits of freedom are widely drawn, conduct which does not form part of any speech or debate in LegCo falls outside Section 3 of the ordinance, and such conduct which creates a disturbance, interrupting proceedings, and interfering with the rights of the other members may attract liability under Section 17C. In conclusion, the correct application of human rights consideration is far from straightforward. The difficulties are compounded by the fact that such rights are fundamental rights. Notwithstanding such fundamental nature, the attribution of overriding significance to such rights can sometimes distort the proper analysis of the issues in question, such as by overlooking the nuances inherent in the principles of legal certainty or proportionality, or the width of the relevant factors to be taken into account, or even the well-established approach to statutory interpretation. It therefore serves well for the legal profession as well as the courts to be extremely vigilant in approaching the subject so as not to fall into the many potential pitfalls along the way. Thank you.
Ladies and gentlemen, as I mentioned at the start, we are privileged to have three distinguished speakers, highly experienced in human rights matters, to speak to us today. Owing to the time constraint, we should perhaps leave follow-up discussions to more casual chats during the break. Once again, please join me in thanking Justice Litton, Benjamin, and Johnny. Thank you.
Thank you very much, our moderator, Ms. Finzi Lam, and also our speakers, Mr. Justice Henry Litton, CEE GBM, Mr. Benjamin Yu, SBS SCJP, and Mr. Johnny Mock, BBS SCJP. Thank you so much for insightful discussion on the interplay between human rights and criminal law. Thank you so much, and please be seated. Just a warm reminder for those who prefer simultaneous interpretation, don't forget to get a headset from the reception. We will have a service in Cantonese and also Putonghua. And now we will have 10 minutes break and resume at around 11:10. 11:15, around 11:15. So I will see you again after 10 minutes, and then let's wait for the second panel. See you in 10 minutes. Thank you. Hello everyone, our second session will start very soon. May
大家請就坐，我們第二個環節呢，馬上就要開始。
嘅嘉賓呢，可以去到接待處借取耳機。在這裡也提醒一下，如果需要即時傳譯服務的嘉賓，可以到接待處借取耳機。謝謝。Hello everyone, welcome back for the second panel session on sentencing offenders, maintaining public confidence in criminal justice. We are so pleased to have Professor Simon Young, the Associate Dean Research in the Faculty of Law, the University of Hong Kong with us today. Professor Young is also the university's Deputy Director of Education and Development for Research Integrity. As a practicing barrister with Parkside Chambers, he specialized in criminal law and public law cases. Professor Young, may I pass the floor to you?
Thank you very much. It's a great honor to be moderating this panel on sentencing. And I think, as all of us know, sentencing, of course, is an enduring aspect of the criminal justice system. And recently, it is very much a topic that is in the public imagination. It's attracting a lot of attention amongst ordinary people in Hong Kong. There also has been some very interesting legal developments in the area of sentencing recently, primarily from two Court of Final Appeal judgments in 2018. Those in the legal profession will be aware of the Joshua Wong decision and also the decision that came after that of Leung Hyu Yeung. Two very important judgments on sentencing, which I think all practitioners should read. The other important development is that in the last 2 years, we have seen a sharp rise in the number of Secretary for Justice applications for review of sentence. I just did a quick tally on the website this morning, and I counted something like 20 decisions rendered in 2020, and already up to now, about 14 decisions rendered by the Court of Appeal in review of sentence cases. I think these are records. I noticed that in the years past, and of course Grenville will have a memory of this, there may be only a small handful of review of sentence cases, sometimes 2 or 3 handed down in 1 year. So when one stands back, one might want to ask, what the heck is going on? Because when one thinks about it, Is it the case that the lower courts are simply getting it wrong and they need to be corrected? Or is it the case that there is defiance? That they know what the law is, but they're defying the law? Or is it the case that they're simply doing what they've been doing, particularly in cases involving young people, and the higher courts are taking a more punitive approach? I think these are fascinating socio-legal questions. We probably won't be able to answer those questions today, but they're worth thinking about. Right, we have 3 excellent presentations today, and I commend the prosecution division for composing 3 authorities in the law of sentencing for today's panel. I'm going to begin by introducing our first speaker, none other than, of course, the Chief Judge of the High Court, Mr. Justice Jeremy Poon, who unfortunately can't be with us, but we do have his pre-recorded presentation. And one benefit of him not being here is that I can tell a little story and maybe get away with it. In April of 2019, I was very fortunate to be in Zambia, of all places, with Mr. Justice Jeremy Poon for the Commonwealth Lawyers or Commonwealth Law Conference. With, of course, there was a huge Hong Kong contingent there as well. And I recall that in the plenary session, I think it was the opening plenary session, I was seated there and we were all listening to the speaker. And I looked over to my right and I saw the Chief Judge sitting next to Mr. Justice Godfrey Lam. He was also there. But the Chief Judge, of course, had his iPad with him and he was busy working away, probably writing a judgment. Meanwhile, the speaker is speaking. I'm sure he was listening to the speaker as well. But this is all to say, of course, this is direct evidence of just how hardworking he is. And probably explains why he's not here with us today. But nevertheless, he did take the time to prepare this speech, and we will all benefit from that. He, of course, has been writing some of those review judgments from the Court of Appeal. And so at this point, may I ask that we play his presentation. So thank you very much, Chief Judge, for reminding us of some of these fundamental principles in the law of sentencing. We now come to our second speaker, and of course, he needs no introduction at all. Mr. Grenville Cross, Senior Counsel, Queen's Counsel, has been serving the community for decades. Of course, for a significant period as the Director of Public Prosecutions at the international level of the Association of International Prosecutors, and more recently as a commentator on very important criminal justice issues, and he doesn't shy away from difficult issues as well. And of course, he is probably the leading authority and most prolific writer on the law of sentencing in Hong Kong. People in this room probably all know about his famous work, Cross and Jurong on evidence or on sentencing. And of course, something that I'm most grateful for, he serves as the sentencing editor for Archbold Hong Kong. I would, as a bit of a taster, say to all of you that look forward to his comments in Archbold 2022, which will come out very soon, on the relevant sentencing principles when it comes to national security law offenses. Some very insightful discussion in the next Archbold volume. Grenville?
Good morning, ladies and gentlemen. I'm most grateful to the Secretary for Justice I'm most grateful to the Secretary for Justice for inviting me to participate in today's conference and to share with you my thoughts on how criminal justice can maintain public confidence in the sentencing system. At the outset, it should, I think, be emphasized that the sentencing of offenders is rarely easy, and that there are, of course, many pitfalls in the way of the unwary. The former Lord Chancellor of Great Britain, Lord Hailsham of St Marylebone, once described sentencing as, quote, the most responsible task which any court of criminal jurisdiction has to perform. Indeed, judicial officers have sometimes been heard to say that in comparison with the sentencing of the defendant, the trying of him is easy. And this, I think, is a valid comment, particularly in jurisdictions such as ours, where mandatory sentences are rare and the judicial discretion is wide. Now, although undue leniency can weaken respect for the legal system, undue harshness certainly does not promote the interests of justice. The options available to judges and magistrates when they sentence offenders can be considerable. And while this is undoubtedly a good thing, it certainly does not simplify their task. They will often be criticised for their sentences, particularly when they have erred on the side of leniency. So as a preliminary issue, it is, I think, necessary to say something about the extent to which the courts should pay regard to public opinion when they punish offenders. Now, in 1993, the then Lord Chief Justice of England and Wales, Lord Taylor of Gosforth, said that sentences should not be so far out of touch with the expectations of ordinary law-abiding citizens as to create discontent. And as recent events have shown, those remarks have obvious force. Once offenders are convicted, there are often calls for severe sentences to be imposed, and less frequently, there are pleas for leniency. The victims of crime and their friends and relatives may be particularly vocal, and others in the community, whether commentators, concerned groups, or politicians, sometimes demand condign punishment. Although it is undoubtedly true that judicial officers do not have to reflect the views of the public, they cannot completely ignore them. At the same time, the courts have a duty to try to lead public opinion. And indeed, another former Lord Chief Justice of England and Wales, Lord Bingham of Cornhill, once explained it in this way, and I quote, "I do not consider it would be right, even if it were possible, for judges to ignore the opinion of the public. They do not live the life of hermits. They are in and of the world, and they are invariably alive to the opinions of their fellow citizens. The judges are also conscious that the gift of infallibility is not conferred on them alone among mortals. So when differences of opinion arise on issues of sentencing between the judges and an identifiable body of public opinion, the judges are bound to reflect whether it may be that the public are right and that they are wrong." Close quote. However, before any weight can be attached to public opinion, that opinion must clearly be informed. All too often, those who condemn the judiciary the loudest actually know very little about the case and rely solely on media reportage, which can actually be superficial. It is vital, therefore, that everything possible is done to ensure that the basis of particular decisions is not only clearly explained to those involved in the proceedings, but also disseminated in understandable terms to the wider public. Although the courts, of course, cannot allow themselves to be stampeded by public opinion into imposing draconian punishments which are not strictly justified, they must also do everything they can to promote understanding and transparency, most obviously through their reasons for sentence. Now, the courts at all levels should always try to provide reasons for sentencing decisions, which, if not lengthy, are clear and particularized, as this can help to guide public opinion. Although this, of course, invariably happens in the higher courts, most cases are tried summarily, where the pressure on magistrates is often intense, and unless the case is high profile, only brief reasons for sentence are generally supplied, although these are subsequently fleshed out if there is an appeal against sentence. If, however, judicial officers at whatever level can provide cogent reasons for sentence when imposing the sentence, however time-consuming that may be, this will, apart from assisting the crime victims themselves, also reduce the scope for error. After all, the formulation of reasons requires the court to focus its mind on all relevant issues, including the aggravating and mitigating factors, the precedent cases, and the sentencing options. Anything that can be done to promote greater public understanding of particular decisions should be encouraged, as this will reduce unfair criticisms of the judiciary, particularly in sensitive cases. If, moreover, the media itself can devote greater coverage to the reasons behind sentencing decisions, this will certainly help in making the public better informed. Indeed, in October 2020, the judiciary itself took a significant step to make its processes more understandable. It announced that summaries of selected decisions in the district court and the magistrates' court, which might attract what it called great public attention, would, so far as practicable, be prepared and uploaded onto the judiciary website. Wherever possible, therefore, this should include sentencing judgments, so that people who are concerned by a particular punishment no longer have to rely on the media for their information. When they have access to what is, in effect, a tailor-made explanation from the judiciary, and that is readily understandable, this should go a long way towards allaying public concerns. Now, although the judiciary's initiative is clearly an important example of open justice in operation, the courts will still require every assistance from counsel if they are to achieve just outcomes. And I'd like now to turn to the issue of the prosecutor's right of address. In a trial proper, of course, the counsel for the prosecution and for the defence enjoy an equal right to address the court on the issues of guilt or innocence. However, at the sentencing stage of the trial, the right of address is confined to defence counsel. And since 1988, when the Court of Appeal pronounced upon this issue in the landmark judgment of Attorney General and Jim Chong-shing, to which reference has been made, the role of the prosecutor has basically been to providing a trial court with tariff or guideline judgments, together, of course, with the offender's criminal antecedents and the victim impact statement, if any. Upon invitation, the prosecutor may also provide statistics and information about the offence prevalence, and that is basically the extent of the assistance that may be given. Indeed, on one point, the Court of Appeal was emphatic, insisting that the prosecutor must, quote, be careful not to suggest any particular sentence or type of sentence and say anything that could be taken as advocating severity. Now, the rationale of this approach has always been, as Chief Judge Poon pointed out, that as a Minister of Justice, the role of the prosecutor is confined to assisting the court in an even-handed way to achieve a just outcome, and that the prosecutor has no interest in the case being disposed of in one way or another. In other words, it is perfectly acceptable for the defence counsel to submit that a lower sentence is appropriate, but not for the prosecutor to suggest the contrary. This means, of course, that the court only has the advantage of the submissions of one of the parties, and this can and does produce error, which cannot be, I suggest, in the public interest. Indeed, the prosecutor who represents the public interest does have an interest in the outcome of the sentencing exercise, not least because, as has been mentioned already, if it miscarries, the Secretary of Justice may have to institute a review of sentence. A review, of course, can be traumatic for the offender who faces the prospect of being sentenced a second time, and it is also costly and time-consuming, drawing heavily on judicial and other resources. If an appropriate sentence is imposed at trial, however, this, I would suggest, is clearly in everybody's interests. In England and Wales, the Attorney General's guidelines on the prosecutor's role in sentencing indicate that a prosecutor represents the public interest and should be ready to assist a court to reach a decision on the appropriate sentence. This, however, is confined to drawing the court's attention to victim impact statements, evidence of a crime's impact on a community, statutory provisions relevant to the offender and the offence under consideration, sentencing guidelines, and, interestingly, the aggravating and mitigating features of the offence under consideration. Quite clearly, therefore, a prosecutor in that jurisdiction has no right to seek a severe sentence, but he or she can still go further than is allowed in Hong Kong, most notably by indicating aggravating and mitigating features to which the court should have regard, and explaining the impact that the offence has had upon people living in a particular area. In the United States, however, prosecutors enjoy far greater leeway. By virtue of the federal rules of criminal procedure, both defenders and prosecutors are given what is called an opportunity to speak. This right was notably exercised in June at the sentencing of Derek Chauvin, the former Minneapolis police officer convicted of the murder of George Floyd. After prosecutors filed a sentencing brief and highlighted 4 aggravating factors in Floyd's murder, they told the sentencing judge, Judge Peter Carhill, that he should take the next step and hold that each of these aggravating factors provided a basis for imposing a sentence 2 times the upper end of the presumptive sentencing range, and they asked specifically for a sentence of 30 years imprisonment. And in a separate brief, Chauvin's lawyers asked for a downward departure from the sentencing guidelines or a sentence of probation, which reflected the time already served behind bars. In the event, Chauvin was sentenced to 22.5 years imprisonment, and there are, I would have thought, lessons to be learned from the way that cases like that are handled. Now, speaking as the prosecutor who represented the Attorney General in the Court of Appeal in the Jim Chong-Shing case, it seems to me that things have now moved on and that the public interest will be best served if the prosecutor enjoys an enhanced role in sentencing. Indeed, there is no reason to suppose that the courts will not be greatly assisted by the direct input of the prosecutor concerning the appropriate sentence, provided it is done in a measured and a thorough way. It is surely anomalous that only one party can be heard at the sentencing stage, notwithstanding that prior to that point, on every other issue in the trial, both parties have been allowed to present their submissions. It is, I suggest, no more than a statement of the obvious, that if the prosecutor was allowed to make submissions on sentence, this could benefit the court, reduce the chances of errors arising, and help to avoid the need for subsequent sentencing reviews in the Court of Appeal. Of course, if the prosecutor overstepped the mark and indulged in inflammatory rhetoric, something which is prescribed by the Department of Justice's own prosecution code, he or she would be pulled up by the court. But this, of course, is equally true of defense counsel, who is also subject to a separate professional code. This, however, I suggest, is not likely to arise, as both prosecutors and defenders invariably observe the proprieties and understand the parameters within which they operate. Indeed, it is hard to see what logical objection there could be to a prosecutor in, for example, a drug trafficking case, saying to the judge, "My lord, given the absence of remorse, the prevalence of the offence, and the quantity of pure narcotics, and taking into account the aggravating factors, which include recidivism, the international element, and the recruitment of young persons, we submit that a deterrent sentence is unavoidable, and that according to the guidelines, and subject to my learned friend's mitigation, a sentence in the upper band of sentencing is appropriate, by which we mean a sentence of between 15 and 20 years imprisonment." Now, a submission of that type could certainly do no harm and might actually do some good, not least because if a correct sentence is achieved, it enhances public confidence in the sentencing process. And the same, of course, can also be said of consistent sentencing to which a prosecutorial right of address can also contribute. Now, there can, I would have thought, be little dispute that consistency of sentencing is absolutely essential. There should not, save for good reason, be wide fluctuations in the sentencing of offenders who commit the same type of offence in broadly similar circumstances. If consistency is achieved, it eliminates the notion of judicial lottery in being sentenced by one court rather than another, and it has even been described as a vital constitutional principle, CHKSER and Chow Chun-yi. Although, of course, consistency of approach does not mean that each and every case has to be dealt with in exactly the same way, regardless of the aggravating or mitigating factors, what it does mean is that a court should provide some cogent reasons for stepping outside the usual sentencing range. If this does not happen, public confidence could suffer, with people questioning why cases that appear similar are being disposed of differently. And quite clearly, one way to promote consistency is for the courts to follow the judicial signposts when they sentence offenders. By this I mean the sentencing guidelines or tariff judgments which the appellate courts have issued in relation to some, but by no means all offences. Although courts, of course, can always depart from the guidelines for good reason, whether by upward or downward revision, the existence of guidelines goes a long way towards reassuring the public that sentencing is being properly conducted. Although the Court of Appeal has sometimes expressed reluctance to promulgate new guidelines, they are invariably of great utility, and I believe that, if anything, there should be more of them, or at least more tariff judgments. I say that particularly having regard to the large number of new offences that have been created in recent times, including doxing, upskirting, and voyeurism, and in which trial courts, in the absence of any appellate guidance, may be expected to impose widely divergent sentences, at least to start with. But a big question these days, of course, is how sentencing guidelines should come about, and there have been calls for a sentencing council, and it is to that I now turn. Since the 1970s, the Court of Appeal has been responsible for providing sentencing guidance to the trial courts. As the then Chief Justice, Sir Dennis Roberts, explained in 1979 in the case of Chen Chi-ming and the Crown, the Court of Appeal's duty is, quote, to give guidance to courts within the territory, and basic fairness to convicted persons requires, quote, a substantial degree of consistency in the punishment to be imposed for similar offences. And since that time, the court has issued very helpful sentencing guidelines in relation to an array of offences, including burglary, child pornography, drug trafficking, rape and robbery, with the impact of aggravating and mitigating factors being carefully explained. Sometimes guidelines have been formulated to nip a new type of offending in the bud, as where a new narcotic appears. Since, moreover, they are not cast in stone, updating is sometimes necessary to reflect latest developments, as, for example, when an upsurge of head-bashing robberies aroused concern a few years ago, and a revision of the robbery guidelines was made. Whenever guidelines are required, the Court of Appeal has ensured that extensive research is conducted and has obtained information on, for example, the impact of a particular crime on its victims, the prevalence of the offence, and the views of the experts. And useful guidelines have resulted. In recent times, however, there have been calls for a new system, whereby the promulgation of guidelines becomes the responsibility of a sentencing council, such as exists in some other common law jurisdictions. It has to be said that many of those calls have emanated from people who are unhappy with particular sentencing decisions, and who imagine that if a sentencing council were to be created, the courts would lose their discretion and be obliged to impose higher sentences. This, however, is a misconception, and that is not how such bodies work. In England and Wales, for example, there is a sentencing council which promulgates guidelines for particular offences. Historically, the Court of Appeal in England, as in Hong Kong, took the initiative in developing guideline judgments as a means of assisting trial courts in relation to the more serious crimes, likely to attract long terms of imprisonment. In 1998, however, this changed when the Sentencing Advisory Panel was created to assist and advise the Court of Appeal on the development of sentencing guidelines and to conduct research. And in 2003, the Sentencing Guidelines Council was established with the function of issuing sentencing guidelines, and with the Sentencing Advisory Panel now advising the Council rather than the Court of Appeal. And in 2009, both the panel and the Council were replaced by the new Sentencing Council, which now comprises 8 members of the judiciary and 6 non-judicial officers, all with expertise in criminal justice. And in consequence, sentencing guidelines are now developed in one of 2 ways, either by the Sentencing Council, which is the usual way, or by the Court of Appeal itself issuing guideline judgments, which is the traditional way. And since 2010, the law has provided that a judge must follow any relevant sentencing guidelines unless it is contrary to the interests of justice to do so. In other words, the court has a leeway to depart from them for good reason. Now, the English sentencing guidelines set out sentence ranges for particular offences, reflecting different levels of seriousness, and within each range, a starting point for sentence is indicated. The guidelines also provide guidance on factors the court should take into account that may result in a more or less severe sentence being imposed. In, for example, a theft or burglary in a building other than a private building, the offence is treated as aggravated if there are offenders operating in a gang, if vulnerable witnesses are deliberately targeted, and if there is a high level of gain. The offence, however, is treated as mitigated if the defendant has returned the stolen property or if the defendant acted out of desperation or need. The Sentencing Council develops its guidelines in a structured way. It may decide to consider a topic itself or after a referral of the topic to it. Once it takes the topic on board, the Council publishes a consultation paper on the topic and a draft guideline, and there is then a 3-month consultation period. Having considered the responses, the Council then issues its definitive guideline, which is generally binding on all courts in England and Wales. Thereafter, the Council monitors the operation of the guideline so that it can, if necessary, be amended in future. In addition, the Council assesses the impact of guidelines on sentencing practice and the impact of sentencing decisions on victims. But it is clear, however, that regardless of whether guidelines are issued by the Court of Appeal, as in Hong Kong, or by a sentencing council, as in England and Wales, the effect on the trial courts is exactly the same. In both places, research is conducted before guidelines are issued, and once they are in place, they are normally followed, although the judges can, as I say, depart from them for good reason. Whereas, moreover, a sentencing council may be of particular value in a large jurisdiction where courts in one part of the country have no idea how sentencing issues are being handled by the courts in another part, leading to inconsistent approaches and public grievances. This cannot be said of Hong Kong. In comparison to England and Wales, Hong Kong is, of course, a tiny jurisdiction, and there is regular liaison between the courts, with the Judicial Institute also keeping judicial officers abreast of sentencing developments. The Court of Appeal has its finger on the pulse in the sense of discerning inconsistent sentencing trends which require remedying, whether through guideline or tariff judgments. When errors appear, as where, for example, wholly concurrent sentences are imposed on offenders who are already serving sentences for identical offences, meaning no actual punishment is imposed, the Court of Appeal can correct the matter on review, while the Judicial Institute itself can remind judicial officers of the importance of consecutive or partly consecutive sentences in its training seminars. Indeed, I would have thought that the Judicial Institute is best placed to ensure that judicial officers are fully apprised of sentencing principles and later sentencing issues, and I'm sure it is already ensuring this. What all this boils down to, therefore, ladies and gentlemen, is that there is already in place adequate machinery to monitor and, where necessary, correct sentences passed by trial judges. A sentencing council would add nothing of value, in my opinion, and might even usurp the function of the independent judiciary. When all is said and done, the present system, as it has developed since the 1970s, works well, and a new mechanism to guide the courts is not required. Now let me turn to victims of crime. If public confidence is going to be maintained in sentencing, it is vital that victims of crime, whether direct or indirect, are appropriately treated. This does not mean that their views should be solicited on the actual sentence to be imposed, but that the impact of the crime upon them should be fully ascertained before punishment is passed. As a result of the Victims of Crime Charter of 2007 and the Prosecution Code of 2013, everybody now appreciates that the voices of the victims should be heard and that prosecutors have a duty to ensure this. Quite clearly, before the passing of sentence, judicial officers need to understand how the offence has affected the victim personally, emotionally, and financially. After all, one of the purposes of sentencing is to assuage the feelings of victims, their relatives, and their friends. And if this does not happen, they may be tempted to take the law into their own hands and to mete out summary punishment of their own, as sometimes happens. However, although the various protocols are all very helpful in their own way, they lack a statutory basis, at least for the most part. The trial courts can even decline to receive a victim impact statement, let alone to hear from the victim. But even if the court takes the view that the victim has nothing useful to say and that the impact of the crime is obvious, it is important, I think, not to underestimate the cathartic effect which the actual giving of testimony can have for the victim. For the victim to know that he or she has actually played a part in achieving justice and not simply been a cog in the process is a highly significant factor in maintaining public confidence in the legal system. If conversely, a victim feels cheated by being denied his or her day in court, this may damage public trust. Indeed, the time has surely come to move to a higher level and to enshrine victims' rights in legislation through a Victims of Crime Ordinance. Although it is certainly true that under the Organised and Serious Crimes Ordinance, the prosecution can provide a court with information about the effects of a crime on any person, this only applies to particular offences, and even then, it does not extend to all the trial courts, only the higher ones. What is required, therefore, is a comprehensive victims' law, such as already exists in places like Australia, Ireland, and New Zealand, and which reflects the obligations which the criminal justice system owes to those who suffer harm, not only at the sentencing stage, but from the time the offence occurs and throughout the entirety of the trial. On September the 30th, the British government announced that in response to a horrific murder case which occurred on March the 3rd, and in which Sarah Everard, a 33-year-old lady, was raped and killed by a serving police officer, Wayne Couzens, it plans to fast-track a victims' bill. Although the bill's details have yet to be announced, it appears that victims will acquire a greater involvement in the sentencing process, and this, I would suggest, needs to be monitored by the Department of Justice. A central feature of a victim's law would be the entitlement of a victim to inform the court directly of the offence's effects, whether immediate or long-term. It would also provide the victim with an opportunity to explain if it has left him or her feeling vulnerable or intimidated, and to disclose any other matters relevant or of assistance to the court. And it is, of course, not only the victims, but also their relatives and their friends who can be badly affected by the crime. And there will certainly be cases where their voices should also be heard prior to sentence. Indeed, in the Wayne Couzens murder trial at the Old Bailey in September, the mother, father, and sister of Sarah Everard not only provided victim statements, but also addressed Lord Justice Fulford directly. They each explained to him the devastating impact of Couzens' criminality upon their lives and how they had suffered by the loss of their family member. In sentencing, the judge paid tribute to the dignity of the Everard family and said their statements had, quote, revealed the human impact of Couzens' offending. He then imposed a whole life sentence upon him. And after the sentencing exercise was over, the Everard family said they were, quote, pleased with the sentence and observed that the knowledge that Couzens would be imprisoned forever had brought them, quote, some relief. It appears, therefore, that while devastated by their loss, the family's close involvement in the sentencing process had a beneficial effect, and they were able to draw comfort from knowing that they had helped to ensure that Couzens received his just deserts. By virtue of having played a role, the family was left with the feeling that the criminal justice system had served it well, and the public will also have shared its satisfaction. It is clear, therefore, that cases of this sort can provide important lessons for this jurisdiction, where victims sometimes have the impression they are simply bit-part players. Although viva voce evidence by victims, their relatives and friends at the sentencing stage of the trial is at most highly rare in Hong Kong, a strong case exists for reviewing its use. Even if a judge has already basically decided what the sentence should be, a victim who wants to be heard should be heard, not least because it can assist the healing process. I'm thinking here, for example, of the parents of the child whose child was kidnapped, the woman who was brutally attacked on the way home, and the family whose lives have been turned upside down by the loss of their life savings through fraudulent activity. When victims testify as part of the sentencing exercise, it gives them their day in court, enables the judge to learn firsthand of their ordeal, and enhances public confidence in the ultimate sentence, as is recognized elsewhere. In the United States, for example, the federal rules of criminal procedure stipulate, quote, that before imposing sentence, the court must address any victim of the crime who is present at sentencing and must permit the victim to be reasonably heard, close quote. Indeed, almost all the states in the United States have laws on victim participation in the sentencing process, with some even going so far as to require the courts to have regard to the victim's view on the actual sentence itself. In Australia, the Crimes Act of 1914 was amended in 2013 to facilitate the use of victim impact statements in the sentencing of federal offenders, and it contains significant provisions whereby the statement may be either oral or written, and it can be made by the individual victim or by a member of the victim's family, or with the court's consent by a person appointed by the court. Quite clearly, if the court can receive direct information about the effect of the crime on the victim, as well as on others, this will help it to evaluate the gravity of the offence for sentencing purposes. The greater the information available and the more direct its mode of presentation, the lesser will be the chances of an inappropriate sentence being imposed. And I should add that in England and Wales, there is a victims commissioner, and there is also one for London itself. As the title suggests, the commissioner is responsible for all aspects of victim welfare and giving victims a voice. And this includes ensuring that victims are appropriately treated by the court system, up to and including the sentencing exercise. If, as I suggest, a victims law is to be considered for Hong Kong, the possibility of also creating a victims commissioner at the same time will be deserving of serious examination. Now, in conclusion, ladies and gentlemen, in their light opera, The Mikado, Gilbert and Sullivan's Mikado was entirely clear of the objective of his sentencing policy. He declared, "My object all sublime, I shall achieve in time, to let the punishment fit the crime, the punishment fit the crime." Alas, the Mikado was not legally trained, and if he had been, he would have known that sentencing is not mechanical and that the sentence must also fit the criminal. He would also have appreciated the sentence should be one which leaves the public with the feeling that justice has been done. This, however, as many of you will know from direct experience, can sometimes be far from easy, but it's certainly not impossible. Thank you very much.
Thank you very much, Grenville, for that thorough discussion of a wide range of important issues on public confidence. Mikado, of course, is famous for the other sentencing expression, short, sharp, shock, as well. All right, we now come to our third speaker, and Mr. Jonathan Mann in this room requires no introduction as well. He is the acting deputy DPP. He's head of the subdivision responsible for matters arising out of the magistrates' court, including magistracy appeals. And he is also a distinguished litigator in many cases. We see his name in many important cases, including the recent case in the Court of Final Appeal concerning Sixtus Leung. But he was also counsel in the important sentencing case, which I mentioned earlier, Leung Hui Yeung, in 2018. So Jonathan, may I invite you to give your presentation?
Ladies and gentlemen, looking at the time, good afternoon. In the past 2 years in Hong Kong, there has been a rather robust exercise of the appellate jurisdiction in the CA in the review of sentencing proceedings initiated by the prosecution, which draws significant public attention. In contrast with the traditional viewpoint that prosecutors shall take up a rather limited and less active role during the sentencing stage, an interesting, if not somewhat paradoxical, dichotomy arises. On one hand, prosecutors shall avoid influence the sentencing judge by advocacy, the quantum of sentence to be imposed. On the other hand, they can later make detailed legal submissions to a higher court of why the sentence passed is manifestly inadequate. Across other common law jurisdictions, it seems that there is a change from the traditional viewpoint that prosecutors' role shall be kept at a minimum towards allowing prosecutions to have more input. In some jurisdictions, prosecutors are now allowed to make sentencing recommendations to the judges at the trial court, while in some other jurisdictions, such notion is still rejected. Against this backdrop, I would like to take this opportunity to throw out an open question for discussion. The question is, in Hong Kong, should prosecutors be allowed to make sentencing recommendations at sentencing hearings? Let me begin by saying how we see our role as a prosecutor in the sentencing process in Hong Kong. Our view is clearly manifest in the Prosecution Code. Prosecution Code stipulates that a prosecutor has an active role to play in the sentencing process by assisting the court to impose the appropriate penalty and to avoid appealable error. But a prosecutor should not attempt by advocacy to influence the court in relation to the content of sentence. It has been said many, many times. In the case of Hong Kong SAR and Chang Yu-sheng decided in 2018, a court of the first instance reiterated that it has been a long-established practice that prosecuting counsel should not influence the trial court by advocacy in terms of sentence, nor should be permitted to invite the court to pass a heavier sentence or a specific type of sentence, which heightened the rather restrictive approach Hong Kong courts are taking in the purview of what the prosecutors can do in the sentencing process. Before we dive into the breadth of the role of a prosecutor in sentencing, I would like to stress that prosecutors do actually have an active and important role in the process of sentencing, regardless of what they can say and cannot say in the hearing. Prosecutors have both direct and indirect influence on sentencing and its outcomes in the criminal justice process. They directly impact outcomes through the decision to prosecute, charging choice, choosing the mode of trial, and adducing evidence placed before the court. They also impact sentencing outcomes through their roles in negotiating charges, affording diversion from prosecution, amending omitted facts for sentencing purposes, and present information and submissions to court. Throughout the criminal justice process, prosecutors have penal aims in mind, and there are inevitably certain degrees of discretion vested with them. There's no question that prosecutors shall participate in the process, sentencing process. Rather, the real question is how they shall participate and what sort of roles they should assume in the process. In the case of AG reference number 7 of 1997, Lord Bingham decided the case. He said that the practice of reticence adopted by prosecuting counsel during the sentencing process developed during the days before the AG had the power to refer unduly lenient sentences to the Court of Appeal. Developed at the time when sentencing provisions were less complex, less complicated, and at the time before sentencing decisions were as fully reported as they are now. When we take a look at other common law jurisdictions, there seems to be a paradigm shift from the more traditional view of the less active role played by the prosecutors to a more expansionist approach where the prosecutors take up a more active role. Similar to the position in Hong Kong, in the UK, New Zealand, and Australia, prosecutors are duty bound to assist the court in reaching a sentence and to prevent it from falling into appealable error. This requires them to proactively draw sentencing judges' attention to relevant information. The paradigm shift high point turns on whether prosecutors are permitted to make recommendations so as to to appropriate sentence in their submissions to the court. In some jurisdictions, prosecutors are expected to make sentencing recommendations. In the US, federal prosecutors make robust and detailed submissions at sentencing stage and have an indispensable role in advocating for sentencing recommendation. In New Zealand, prosecutors must not press for a particular term of imprisonment or any other sentence, but may permit to submit a view as to the appropriate sentence range or tariff. Likewise, in the UK, the prosecution advocate may offer assistance to the court by making submissions as to the appropriate sentencing range. Singapore's position is this: the prosecutor is usually allowed to make recommendations to the court on an appropriate sentence. Australia, the position is a little bit controversial. Following the Victoria's Court of Appeal decision in the case of Queen against McNeil Brown, 2008, it was the common practice for the prosecutors to submit what they considered to be available sentencing range when they are asked to do so by the judge. However, in a later judgment by the name of Barbaro and Queen decided in 2014, the High Court of Australia overruled McNeil Brown and held that it was wrong in principle for the prosecution to proffer a statement of the grounds within which a sentence may be imposed. It is for the sentencing judge alone to decide what sentence will be imposed. There are two reasons which I believe contribute towards the paradigm shift. The first is the advent of appellate review of undue lenience at sentencing across common law jurisdictions, with Hong Kong being no exception. The second is the increasing complexity of the laws and statutory provisions on sentencing. Nowadays, courts have a wider discretion over an array of different sentencing options. The first reason is particularly relevant in Hong Kong. In the past 2 years, there is a line of cases in which the prosecution sought review of sentencing at the Court of Appeal. There also has been an outcry among the general public that there should be greater accountability in the criminal justice system. Next, I'm going to argue from both sides of the grounds for and against allowing prosecutions to make sentencing recommendations during sentencing hearing. First, the arguments against allowing prosecutors to make recommendations. The primary argument against expanding prosecution's role in sentencing is the traditional distinction between the roles of the judges and those of the prosecutors. Judges should be the person responsible for passing the sentence. Prosecutorial influence in sentencing may be regarded as infringing the principle of judicial autonomy, which guards against undue influence over judicial decisions. In Barbaro, that is the High Court of the Australian case, decided that it decides against that it is for the prosecution being allowed to make statement in relation to the range of sentence, because it may lead to erroneous views about its importance in the process of sentencing, which consequential blurring of what should be a sharp distinction between the role of the judge and the role of the prosecution in the process. In that case, defendants plead guilty to serious drug offenses. Before they did so, there were discussions between the prosecution and the defense about the charges should be preferred, during which the prosecution told the defense about the sentencing range in respect of the defendants. At the sentencing hearing, the judge said she would not ask the parties to indicate the range of sentence to be imposed. On appeal, the defendants argued that the prosecutor should be allowed to make submissions on the sentencing range, and that had this been done, the prosecutor should have permitted that the range had an upper limit which was less than the sentences ultimately imposed on the defendants. This case is quite unusual, right? In that the defense was contending that the prosecution should be permitted to express their view on sentencing. The High Court of Australia dismissed the appeal and held that the prosecution's statement of what is the range of sentences is a statement of opinion, which advances no proposition of law that a sentencing judge may properly take into account. If the prosecutor is permitted to proffer a statement of a range of sentences, will it assist the sentencing judge to come to a fair and proper result? The answer, according to the High Court of Australia, is that it depends on whether the prosecution can determine the supposed range dispassionately. This, in turn, depends on whether the prosecution can act not only fairly, but also in the role of a surrogate judge, which is not the role of the prosecutor at all. Surrogate judge. It seems that I'm running out of time. So let's forget other argument against allowing prosecutors to make recommendation. Go straight to the arguments for allowing prosecutors to make recommendation. On the other side of the argument, the public interest element and the defendant's interest should both be represented at sentencing. Our system is an adversarial one, which is based on the premise that the judge will be assisted by competing submissions from both sides and will be able impartially to decide which of the submissions is to be preferred. Having heard only half of the arguments may lead judges to produce inferior decisions. On the other hand, to allow the prosecution to make submissions on sentencing may be able to assist the court to avoid appealable errors, which is a common law duty vested with prosecutors. A submission on sentencing range is no different from any other submission which counsel makes, whether in criminal or civil proceedings. A submission conveys the considered judgment of counsel based on analysis and evaluation of the relevant facts and applicable law. In making the submissions, the prosecutor is assisting the court, and the court shall consider his submissions on the merit of his arguments solely. The court is not bound to accept his suggestions. In assisting the court, prosecutors are acting, as always, in the capacity of Minister of Justice to avoid imposing an inappropriate sentence on the offender. Also, at the time when our sentencing laws become increasingly complex, prosecutors can and should help assist sentencing judges navigate the laws, provided that prosecutors can act dispassionately. So the prosecutor's participation can be conducive to the aim to achieve greater consistency and fairly, which is of fundamental importance to public confidence in the criminal justice system and to the maintenance of the rule of law. More importantly, while prosecutors may not make any advocacy at the sentencing hearing under the current regime, the prosecution can, however, express their stance on the sentence and make detailed submissions to a high court on why the sentence passed by the sentencing judge is too lenient. If the appellate court can be told after the event on an appeal by the prosecution that the sentence the sentencing judge imposed is manifestly inadequate for reasons articulated at the review hearing, the sentencing judge should, in principle, be expected to be assisted by a prosecution submission as to at least the available range of sentence, supported by such exposition of the reasons for that range as might at that time seem both probable and appropriate. Let's jump to the conclusion remark. Suddenly, I choose this. As concluding remarks, regardless of whether and how the regime will be changed, the prosecution, including myself, shall always bear in mind our duties and responsibilities and virtues that we shall display in discharging our duties. That a prosecutor is a minister of justice who must endeavor to ensure that criminal justice process is fair and can be seen to advance the interests of justice. If you now ask me to choose to vote for or against allowing prosecutor to have more rights in sentencing, I vote for, just like you. Thank you very much.
Thank you very much, Jonathan, for keeping that brief and to the point. Now I hear a lot of stomachs grumbling at the moment, but if you allow me, I would like to ask a question because I don't know if I'll have another opportunity like this. Both of you have spoken about the role of the prosecutor in sentencing, and obviously, Grenville, you speak in favor of an enhanced role. And although, Jonathan, you talked in your paper anyways, you were going to keep the question open, but now it seems quite clear that you are in favor. So my question is this. Looking at the issue from the defense bar, I think there would be lots of concerns that if prosecutors become more active and become more adversarial, this will have the effect of ramping up the sentences. And it could increase the number of sentence appeals. So you might not actually have any savings in judicial resources. So what would be your reply to that challenge?
I wonder whether it will be the effect like what you said about the increase of the appeal cases. What I've been thinking is that what the prosecutor is going to do in the sentencing stage is to assist the court. It is not the role of the prosecutor to blindly ask for an increase of the penalty to be imposed on the defendant. What the prosecution is supposed to do is to refer to what the prosecutor is not allowed to do is say, for example, aggravating factors, by making reference to factual situations, factual basis. So in other words, it is helping the sentencing judge to make a much proper, appropriate decision on sentencing. So if the ultimate sentence is just, so the chance that any parties will appeal will reduce instead of there will be an increase of the sentencing cases. What's your view, Kevin?
Well, it seems to me there's actually no logic at all, as I tried to make clear in my remarks about not allowing the prosecutor to address the court. If the prosecutor could make submissions on every other matter in the course of the trial, it seems very strange to remove that right at the end. Obviously, the prosecutor is not going to go over the board, and it's interesting, as I mentioned, that in England there is a right of address under the Attorney General's guidelines, but the prosecutor should present both the mitigating and the aggravating factors, you see. So if the prosecutor were to enter into it in that sort of spirit, then it would be immensely useful and show that he or she is a minister of justice right up to the point of sentence. And we've already seen at least one case in recent times where the I think it was a magistrate was actually complaining that the prosecutor was not providing any assistance. He said, I'll probably get the sentence wrong now, and then there'll have to be a review to the Court of Appeal. You're not prepared to assist me. And of course, if there ever was a case where a prosecutor went over the top and started making remarks which were inappropriate, you're dealing here with a professional judge or a professional magistrate whose whole training prepares him or her for handling that type of situation. In the course of a trial, for example, a magistrate or a judge may have to make a ruling as to whether to allow into evidence about the defendant's criminal convictions. If he decides not to allow that evidence in, then he's aware of it, but nonetheless he has to exclude it from his mind because it's not relevant to the sentencing exercise. To the trial proper. And so, if a judge can be relied upon to exclude prejudicial material of that type, then he or she can certainly exclude anything which is improper, which is said by the prosecutor at the sentencing stage. And I would have thought as well that anything could be done to assist the court and to avoid the need for subsequent sentencing reviews is to be encouraged.
Well, no, I think we all agree that we understand assisting the court, and we agree that that should be done. But take your example, Granville, in your paper. You talk about the prosecutor actually recommending or indicating a sentence of, say, 10 to 15 years. Then the defense, imagine they would recommend, of course, 5 to 10 years. Then it becomes very adversarial. Of course, I used to practice in a jurisdiction where there was very few limits at all on prosecutors taking positions on sentence. And that, of course, you have to necessarily see leads into what is known as sentence bargaining, right? Where defense will take a position on sentence, prosecution will take a position on sentence, and then it's presented to the court. That's not always adversarial, because it's also possible for both sides to agree. And in fact, in those cases, we would say that that's a joint submission presented to the court. We both agree that the range should be 10 to 15 years. And that, although it's not binding on the court, but it can be very influential. So would you also advocate that we should also have sentence bargaining?
Well, when we talk about sentence indication, of course, we normally think of the situation such as was brought in by the case of Goodyear in England in 2006, whereby the counsel for the defense can actually say to the judge, on the facts, as you now understand them to be, what will the likely penalty be after trial, and what will it be after a guilty plea? So that I would have thought is unexceptional. I mean, there were those in England who, when that was brought in, said the roof of criminal justice would collapse. And of course it hasn't. It's proved to be exceptionally useful for everyone. And this goes back to my original point, really, that the more information that can be provided to the court to assist on sentencing, the better. And the judge is then, as he's able to do in relation to every other facet of the trial, decide which parts he wants to accept and which parts he wants to reject. So the more is before the court, the better, I would have thought.
Anything to add?
I have to admit that I've known nothing about sentencing bargain, and I cannot see what's the point of having a sentence bargain if it is not binding, and I cannot see the point as what is the advantage to be served if the sentencing judge is not told by the prosecution about reason behind the recommendation of that sentence. What is important is not about what sentence that the prosecution wants, but why. Why is the most important thing?
Obviously, the prosecutor doesn't just pick a figure out of the air. I mean, presumably, if he's aren't urging a particular sentence, he'll be pointing at guidelines or he'll be pointing at similar cases, simply ensuring that the judge or the magistrate has the information in front of him.
That's right. And I think there's an analogy. I mean, you ask what is the reason behind it. The analogy would be now on appeals where, let's say, the prosecution concedes the appeal. But you have to, of course, provide the reasons for the court to approve it. So you're right. I think you make a good point that you have to look at the reasons behind the agreement. Well, I think we're going to have to take the further discussion off stage because I think I hear the stomachs getting louder. So with that, can everyone please join me in thanking all three of our speakers?
Thank you so much, Professor Yang, and also our speakers, Mr. Justice Jeremy Poon, Mr. Granville Cross, GBS SC, and also Mr. Jonathan Mann for the intellectual discussion, focusing on the development in sentencing principles in Hong Kong with reference to the recent Court of Appeal sentence review cases and explore the way ahead. We have now come to the end of the morning session. Don't forget to return the headsets to reception before leaving. The afternoon session will start again at 2 p.m. So I'll see you at 2 p.m. Stay tuned and see you in a bit.